welcome to Docket, presented by Defense Diaries. We're here with another live version of Delphi Unhinged, the case that never sleeps. So it's probably been about 8 days since our last Delphi. I was kind of waiting for some motions to pile up. Specifically, I was waiting really for the motion to DQ to kind of finally appear. We'd heard about it. We heard about it on the hearing. There was supposed to be the third-party culprit stuff that turned out to be the motion to continue the trial. So we got it now, and it's long. It's really, really long. It's 40 pages long. So, hi.
Hi.
And I'd like to introduce my beautiful, brilliant co-host, Allie. What's up, babe?
Hey, babe. Hi, all. Bob's super excited, as you can see.
I am.
He's all worked up.
Excited. Super excited. So, I'm still overall very, very happy that this thing got continued. I think it gives everybody the time that they need to prepare.
I mean, clearly the state's still preparing as well, since they just released a cell phone extraction last week to the defense.
Yeah, I mean, we know how that goes, right? I mean, it is not unusual for the state to be tendering discovery all the way up until trial. I mean, it happens. It's obviously not optimal, but like I say all the time, they're always continually investigating all the way up until trial. So, I don't know that they stop during trial. If the prosecutor's saying, look, man, I need you like in the weeds on some particular issue, then, that's what happens. They need to be in the weeds, and they're still trying to dig stuff up. Now, whether or not, it becomes an issue of whether or not the judge is going to allow for that to be used at trial because of the late discovery. I mean, it really depends on when they discover it. Oh, Nav the EO coming in hard right away. Thank you. We love you so much. Beyond appreciate you. Thank you for that. So, as far as, the late discovery, it's not shocking to me. I mean, it's not like a distinctly Delphi issue. It's every case known to man issue, really. So, but now it's really a non-issue because the defense has plenty of time to sort through it. So, but I think the bigger point is obviously that would have been 2 days into trial, right?
Or they would have just never gotten it. Who knows?
Right. And who knows what it is. I mean, any phone extraction I'd want if I'm the defense, whether it's Allen's, whether it's Libby's, anybody's phone extraction. You've piqued my interest. I want it. And I want it now. So, all right, let's go through.
I'm still shocked. I'm with Michael on that. Like, if that's what he's talking about anyway.
It's 7 years in. Yeah. Good point.
It's not like it's different if it's something that they just come across or they're like, oh, a new test is available. Let's do this. But to just provide an extraction for a phone that they've had for 7 years. I mean, we don't know what it is yet, but so I'm still a little bit more shocked.
Well, I don't know that they're turning in the discovery over to the prosecutor's office pre-arrest. I don't know that they're turning that. I'm sure they're making the prosecutor privy to what, where they're at in the investigation. I don't know that they're handing over everything.
Well, no, but if they're processing it, then it's available to hand
over. Cops aren't processing it in the sense that they're like,
well, they're doing extractions.
Yeah, but they're not getting experts to tell them what the hell the extractions mean.
Well, I mean, it doesn't take much to read text messages. They know what they're looking for.
Or does it? I mean, it's a pretty big
Well,
issue.
the underlying data, I guess, maybe we're learning these days is not as black and white as we may have once thought, I guess.
Well, when we get to McClelland's motion here, he's got Brad and Andy like goofballs. Like they just don't understand how to read
modern technology.
They don't understand pings and technology, and we'll get to that. But it makes the most sense. So I think since the last time we went live, there was a motion for continuance that was filed on the 16th. There's one other one that I don't have.
Another one, what, continuance motion?
No, it was a motion. The one motion I don't have, if you can get it to me, I'll add it to the pile. The motion to get rid of the safekeeping order, to vacate it. And for some
Okay.
reason, I don't have that one. If you email it to me, or if you just want to pop it up when it's time. So that thing's out there as well. And if you guys don't know what the motion for safekeeping is, that's obviously relating to the fact that Richard Allen is currently being housed, we think, in Wabash DLC, Department of Corrections, in a prison, as opposed to where most commonly, like 99% of the time, pretrial detainees are housed in county jails, and that's where they await trial. So they're obviously, still trying to get him moved. So I'll pull up this first motion. I'm just like trying to kill time because that 40 pager is not going to be fun. It's a big one. It's a big one. A lot of Andy telling Gull that she's very, very biased person. You're a very biased person against us. You're incredibly biased. So Brad files this thing on the 16th. So just a couple days ago, well, maybe a day ago. And comes now Brad Rosie, and he is asking that the court continue the hearings set for the 21st through the 23rd of May regarding Allen's purported confessions and the admissibility of the communications between the accused and his state-appointed psychologist. In support of said motion, counsel states as follows. On the 11th day of April, 2024, defendant Allen filed his motion to suppress statements. Said motion is scheduled to be heard in conjunction with various other matters between May 21 and May 23 in the county of Carroll, state of Indiana. Paragraph 2, on the 8th day of May, state of Indiana filed a request for pretrial ruling on admissibility regarding communications between Allen and his assigned psychologist. Said motion is currently scheduled to be heard in conjunction with various other matters between May 21st of 2024 and May 23rd of 2024 in Carroll County. Defense has recently conducted discovery in the form of a deposition of Dr. Monica Walla, the psychologist assigned to Richard Allen at the Westville Correctional Facility. The dep commenced on Wednesday, May 8th, and has yet to be concluded due to time constraints. The parties are in the process of scheduling the remainder of the dep, which is likely to take place in early June of 2024. There were questions posed during the deposition that were not answered by the deponent, Dr. Walla, at the direction of her legal counsel. The defense moved to certify these questions and therein preserve the right to seek the court's intervention in obtaining answers to these certified questions. Do you want to explain how that goes to the people, babe? Like, in general, or were you not paying attention when I was reading?
No, I was, but you were but I was actually contemplating pulling it up and following along because it's harder for me when hearing it's retained. But I think what we're talking about is when you're at a deposition, someone doesn't know the answer, and so then you ask them to provide you the information as part of the, like as part of the dep.
No, I was talking about like so say for instance, I'm at a deposition, I'm deposing anybody, and that person has their attorney there, and I ask a question, their
Right, I
attorney
got it.
objects.
Right.
Well, I was explaining to the people, not you.
Oh, sorry. Go ahead.
Wow. No, that's my game with you. Where
Got
I
it.
ask
Got it.
you to explain things.
Okay.
Okay. And then if I ask the question, their attorney objects, gives the basis of the objection. Typically in a dep, the attorney allows them to, to continue on and answer the question. Sometimes, however, they won't. And at which point I would ask the court reporter to certify the question in order to be able to get in front of the judge. In this case, it would be Judge Gull, and have the judge decide whether or not the witness should be compelled to answer the question. All right. So that's basically what he's asking. So he's clearly certified several questions that she didn't feel comfortable, or her attorney did not feel comfortable her answering. He certified them. Ultimately, those will end up in front of Gull, and Gull will make a decision as to whether or not she has to answer. All right, paragraph 5. Excuse me. Additional time is necessary to not only conclude the deposition, but to attain a certified transcript that might otherwise be used as evidence in the hearings on both parties' motions. This could assist in shortening the presentation of evidence regarding said motions. 6, Rosie has reached out to the state of Indiana, who does object to the request to continue, as to the motion to suppress and as to the state's request for the pretrial ruling on admissibility, both of which relate directly to Dr. Walla and her professional relationship with the accused. And then finally, paragraph 7, defendant Allen respectfully requests that this court issue an order continuing the hearing on defendant Allen's motion to suppress statements and the state's request for pretrial ruling on admissibility and reset the matters on a date convenient for the court as requested by the parties. So that, I mean, it's pretty straightforward and it makes sense. You know, I mean, like she really is kind of a big part of both the admissibility of those confessions that were made to medical staff explicitly. And she is said medical staff. They happen to be in the middle of a deposition with her. There's questions that they need answered, and the judge is going to determine whether or not she's going to require her to answer. And those things seem germane. They seem germane to the hearing in and of itself. So do you have any thoughts on that motion, babe?
Well, I mean, not particularly. And if I recall correctly, when the judge responds to this motion for continuance, and we're addressing this now because there were 2 separate motions to continue filed, and the judge denied this one, and it appears and only makes sense that the next motion that Bob will be getting into was filed after this. And I don't even really know, well, I won't say I don't think we need to read it because it's kind of built into the disqualification motion itself. But if I recall correctly, the judge continued one of the suppression motions that involved this witness. At least I think so, which seems like the right thing to do. It seems like that's the main impetus to them wanting to continue.
Yeah, I mean, without question, that is. So in the interim, we get this order this morning. Okay, and it's relative to a few things. One, that motion to vacate the safekeeping order that I was talking about. Which
I did email you that already.
Oh, you did? All right. You know what? I'm going to go ahead and pull that puppy up first. And I'm not going to do the petition for the funds. I don't know. I just don't think.
It was just the same email. That's why I sent it.
Oh, okay. All right. Okay. So filed on the 13th of May was the motion to vacate the safekeeping order. Again, this is relating to Rick Allen being housed in Wabash DOC. And they've tried this twice. They have failed twice to get him moved. This is the 3rd bite at the apple. And I don't blame them for continuing to try to get him out of DOC, even though he does look better. I mean, in recent photographs that I've seen of him, he's grown his hair out, put some weight back on. He looks physically better. You can't tell jack shit about somebody's mind from how they look physically. That's for certain. So I don't know how his brain is. His body seems to be doing better. Looks like he's eating, which helps with your mind as well. You need to eat.
As does sleeping.
Sleeping definitely helps. Sleeping is a very big factor. All right. So comes now Richard Allen by counsel and respectfully requests the court to vacate the safekeeping order that was dated November 3rd of 2022. In support thereof, they state that on November 3rd of 2022, the then sheriff of Carroll County, Tobe Lesenby, filed his request by the sheriff of Carroll County, Indiana, to transfer the inmate from custody of the sheriff to the custody of the Indiana DOC for safekeeping pursuant to Indiana Code 3533-11-1. On the same day, an order was entered finding that Mr. Allen was an inmate awaiting trial and was in imminent danger of serious bodily injury or death, or represented a substantial threat to the safety of others. 3, Liggett is currently the sheriff of Carroll County. On May 4th or on May 3rd of 2024, counsel for Mr. Allen deposed Liggett. During his dep, Liggett testified as follows, quote, I did not have a problem with Rick Allen going to Cass County. My problem was going to be transport. B, quote, I've never had a problem with Rick Allen staying in a county jail. And those are cited to the depths. All right, hold on. I finally figured out how to switch this thing to scroll. Just so much nicer. Okay. And that was from tips. People just kept giving me tips, which was fantastic. C, Sheriff Liggett has since made arrangements with the Tippecanoe County Jail to house Richard Allen during the trial. Okay, so Liggett's made arrangements now, so that's good.
Well, no, and if I think it was mentioned in the motion to disqualify that the judge had asked Liggett to make those arrangements.
Spoiler alert! Spoiler alert!
Oh, well, okay. I mean,
right. I feel you, babe.
So,
right,
I think, yeah. Sorry.
Go ahead. What were you going to say?
I was just going to say that the defense's point is that the sheriff is saying his issue was the ability or inability previously to transport Richard Allen from a county jail to the courthouse, and he seemed to have figured that out now. So that not being an issue anymore, we should be allowed to get him out of prison and into a jail, which is where he belongs in the first place.
Okay, well, I'm going to call massive bullshit on the whole transport thing. Like as somebody who's been at every hearing with the exception of one, which was in Allen County, there is a massive law enforcement presence at every single time Richard Allen's in that courthouse. So the concept that they can't put a few of those guys on a drive from a county jail that's 10, 15 minutes away is a bunch of bullshit. This is all the same kind of shit they were telling us about Garcia, like how they kept him in solitary for 3 years because he once worked as a prison doctor, which I guess they take as he can now escape any prison anywhere in the country because he has an intimate knowledge of the inner workings of prisons. So, and they really did. They used that for 2 years to keep him in solitary and segregation. And he went nuts. He did. So D, when asked if Richard Allen could stay at the Cass County Jail, Liggett responded that he does not care where Rick Allen is as long as it does not become a manpower issue for him. 6, Liggett also testified that the Indiana DOC does not want to transport Mr. Allen. 7, there is no current evidence that Richard Allen is in danger of serious bodily injury or death, or that he represents a substantial threat to the safety or of others as required by statute or rule. And then 8, the transportation and manpower issues originally surrounding the detention of Richard Allen in a county jail have been resolved. And then finally, counsel for Rick Allen respectfully requested the court vacate the safekeeping order in this matter in order that Richard Allen be housed in either Cass or Tippecanoe County jails until the trial of this matter. So there you go. So there's that. And then I'll pop it back to the order. So this thing dropped yesterday. It's from Gull, obviously. Defendant's motion for continuance reviewed and denied in part. Like she can't even say granted in part. She just can't bring herself to write the word granted with respect to any motions the defense files. She'll like, instead of saying granted in part, which obviously means it was denied in part, she just decides to say that it's denied in part. The court scheduled this hearing at counsel's request, who all indicated that they would make these dates work on their respective calendars. The court will conduct hearings on the 21st to the 23rd of May on defendant's motion to suppress second statement, filed April 15th, 2024. State's objection to defendant's motion to suppress, filed April 15th, 2024. Defendant's motion to compel and motion for sanctions, filed April 23rd of 2024, all of which we have reviewed past lives. And if you're in here now, I'm just going to interrupt real quick. Make sure you're liking, make sure you're sharing, and make sure you're subscribing, please. It's very helpful to Allie and I, helps grow the channel, helps bring more folks to the channel. We think we have pretty good content. We think we actually bring value to the true crime community. And you guys can be a big help to us if you spread the word and put us in the algo with the likes. I think that's what they say. That's what the kids tell me. I don't know for certain. I don't know that it really works, but so there's my hat in hand for the night. And this is interesting because everyone keeps having this assumption that this third party culprit stuff's going to be heard, and I'm not seeing it still. Like, am I blind? Is it like,
Well, yeah, she talks about it's like in the last sentence,
okay?
state's motion for admissibility.
Oh, is that admissibility for the state? For
The
I thought
state
that,
filed a motion about
okay.
determining the admissibility.
Okay. Okay. Filed April 23rd. Defendant's motion to vacate safekeeping filed May 13th. And the state's motion to eliminate filed April 28th of 2024. And defense's response to state's motion to eliminate. So that's what's going to be heard. So as defendant is not prepared to address his motion to suppress filed April 15th, 2024, and the state's motion for admissibility, those matters are continued and will be reset at the conclusion of the hearings May 21st through 23rd. So I don't know that she's going to need 3 days for what she has filed, because clearly the state's motion for admissibility, and you're confident that that's the one, right? That's the one.
I mean, yeah.
Okay.
I mean, now you're making me less confident, but
Well, I mean, I know he had entitled one of his, he being McClellan, had entitled one of his motions. Like he talks, like there's been a couple about admissibility, like, because I thought that was a motion in limine about the three third party culprits. Somebody in the chat will know and can give us the heads up on that. So there's that. Okay, so at this point, the motion to suppress the statements which relate to Walla have been continued in the state's motion for admissibility, which I would hope is the third party stuff. You know, it's like, and let me ask you this. So we're getting close to coming up to the big guy, the motion to DQ, the 40 pager.
okay, so I'm wrong. That motion about the admissibility deals specifically with Monica.
Right. So
Sorry.
do we see the third party culprit stuff in here? I was
I'll
saying
find
this
it.
on the last live. Like, I know it was a motion in limine.
Right. I thought it was for pretrial ruling on admissibility, but that this deals with specifically the mental health, you know, Monica Walla, and whether she, whether she would fall into an exception to confidentiality. So that's what that deals with, not
it's got to
not
be
the
the
third
state's
party.
motion in limine filed April 28th. It's got to be that one. It has to be that one. There's
Right. So
no
that
way
would
you
still
have
go
said it for,
forward, which explains why it would still take so much time.
right. That makes way more sense. All right. So in light of the fact that we had this motion to DQ filed today, all right, like, if you had to take a guess, a wild guess, based on Gull's history in this case, do you think it might have been prudent to wait until after she more likely than not will deny them the ability to introduce third party culprit evidence so that they can appeal that issue as well?
I would say absolutely not, in my opinion. Because I think that you could be stuck with it. It's not that easy to get a judge reversed. So, if there's not a motion pending and the judge rules that, like, not a motion for disqualification pending, which in such a case you wouldn't be allowed to rule on that motion. And sorry, it's not like an abuse of discretion or clearly erroneous. You could be stuck with a ruling that the judge makes, I think.
How is she how does she have the ability to proceed with these motions on May 23rd?
She doesn't anymore, but that motion to disqualify wasn't filed when she entered this order that we're reading right now. At least it appears to have not been filed because
Well, it was the one that they asked her if you want us to put it in her hand, and she wouldn't allow them to file it in Allen Court or Allen County, so she knew it was coming. Like, she certainly can't claim ignorance that it was coming. She
I know,
knew
but
it
it
was
wasn't
coming.
there yet, so she's gonna proceed as normal.
Okay. So I guess what we're telling people is these dates have to get kicked.
Yeah, unless she rules between now and 3 days from now, which would be I mean, that'd be a little much. Unless she rules on the motion to disqualify and says denied, then she can't go to a hearing for anything on the 22nd, 21st, 22nd, or 23rd.
Okay, let's move on. So this was filed today, I believe.
Yeah, because so here's the thing. We received, look at the top. Yeah, what does it gives a time, right? That it was filed.
3:04 p.m.
Right. And we received this order about on the motion to continue at like 8 o'clock this morning. So it was definitely wait, it might have been at 1 o'clock. Yeah, they filed. So
And I asked Michael Osbrook, who's in chat, as I've got his comment up here, if there is any way around the judge not self-regulating on this motion to DQ, meaning another judge sits on it and decides whether or not she should be removed for cause. Because in Illinois,
yeah,
we because it doesn't make any sense to have a judge rule on cause as to whether or not they're biased. I mean, what's she going to say? Is she going to sit on the bench and admit, yeah, I'm biased?
is that are we in the same time zone?
No, they're
Ah,
Eastern.
okay. So then, all right. So then I take it back because we got this email. I don't know when the judge's order was entered, but we got the email at 2:02 our time.
Yeah. Okay.
So that's 2 minutes before this thing got file stamped. That's crazy,
I
right?
mean, ships passing in the night, right? Ships passing in the night. All right. So Brad and Andy file this thing mid-afternoon today. And it says, following a brief hearing on May 7th, which was, of course, supposed to be the third-party culprit day, which I did not go to because I was having a great time in New Orleans, in which the jury trial on this matter was continued from May 13th till October 14th of this year. At that same hearing, the court set several pending matters for hearing on May 21st, 22nd, 23rd. Paragraph 2, during that May 7th hearing, the accused counsel indicated that they would be filing a motion to DQ Judge Gull, and at that time had prepared a motion that they intended on filing that day. 3, however, certain issues have arisen both during and after the hearing, which have caused defense counsel to add to the motion that the defense has prepared. The defense has therefore been adding to that motion, as well as re-editing the motion, taking additional time to prepare said motion for filing. And they're obviously talking about the motion to DQ. Also, in paragraph 5 here, the new motion required Richard Allen's signature, and because he's on the other side of the world, he's been moved back to Wabash Valley Correctional. It's logistically difficult for Richard Allen to review the document and sign the document so that it comports with the legal requirements of a request for DQ. Paragraph 6, Richard Allen has signed the documents as needed, and therefore the defense files its motion to DQ at the same time as this motion to continue next week's hearings. Hand in hand, part and parcel. Paragraph 7, as the court is aware, at the time Richard Allen petitions this court for a change of venue from the judge, this court will be without jurisdiction to do anything other than rule on this motion, citing Lucas v. State.
And I
Which
did
is
look
what we were
that up.
talking about.
So, yep, that's what it says. The court loses jurisdiction to rule on anything but that motion.
Good law, good law.
Yep.
Which makes sense. I mean, you know, she's stripped of her jurisdiction in terms of this case until this thing is resolved. And like Allison said, does she have a workaround? Yes. She can do her typical denied without hearing, her three sentence denial thing, and then proceed as planned.
And they're definitely not anticipating a hearing. They're expecting that she's ruling on the papers based on their actual motion, asking for her.
Which she's going to rule on which papers? The motion to DQ?
Yeah. I mean, that's what it seems to be anticipating because
how do you how do you think that a hearing like that would happen where you're trying to DQ the judge that's sitting on the bench hearing the motion?
Right.
Like how do you, like when we've tried to DQ judges out of cases and it gets kicked up to the chief judge and then the judge assigns it to a different judge. I mean, have we ever had that judge like testify? I can't remember.
We've never done that. And I think
don't know
I
if
had
we
the
can.
issue come up actually in the Andrea Kelly's case. And I can't remember if we said we intended to call the judge and then they said they weren't going to allow the judge to be called. But I know that the judge ultimately wasn't called. But
so Rowing now thinks that defense is running scared from having to do anything on the 21st to the 23rd. Maybe they are. Maybe they're terrified. Terrified of doing their job. Maybe. It's possible. It's possible. Unlikely, but possible. All right. So paragraph 6, Richard Allen has just signed the documents as needed, and therefore the defense files its motion to disqualify at the same time as this motion to continue next week's hearings. 7, as the court is aware, at the time Richard Allen petitions this court for change of venue from the judge, this court will be without jurisdiction. Again, I read that. 8, additionally, defense is requesting Judge Gull to issue. This is such a weird thing to have to ask the judge to do what they should be doing anyway, which is issue findings of fact and conclusions of law, meaning quit writing denied without hearing. Give us a reason. Like if you're going to say denied without hearing for the following reasons, cite the law, cite your conclusions of law and your findings of fact, and then at least the appellate court.
that's what I was going to say. I think those are also keywords for we're going to appeal.
Right. Exactly. So additionally, defense is requesting that Judge Gull issue findings of fact and conclusions of law if she issues a ruling denying the defense motion to have her DQ'd.
And so that's the type of thing I'm saying. It shows that they aren't anticipating a hearing because they're asking her if she denies it, to include, facts and conclusions of law, findings of fact and conclusions of law. So it's like they're anticipating not having an actual hearing.
Yeah. Right. I mean, like, can you blame them? I mean, at this point, she's actually got some hearings going, but of course, the biggest hearing is obviously to the benefit of the state, which is to knock the third party culprit shit out.
And my reading of the couple of cases in this regard, it's supposed to be based on what's in the affidavit. Now, in this one, basically the affidavit was everything that's going to be that was in the 40-page motion that you're about to read to everybody. So in theory, she doesn't need, like an actual hearing to determine if those things are true or not.
Right. Right. 9, therefore, Judge Gull will not be able to conduct a hearing or rule on any matters until she has received the motion to DQ and entered findings of facts and conclusions of law. Well, that's not true. She could very simply write an order that says denied without hearing, and then she could proceed. She doesn't need to, just because they want her to, put findings of fact.
I think she's actually supposed to, according to the statute. I have to revisit it, and I know we've got Michael in here, so maybe he can answer that real quick. But I think that that's part of what is required in her order. I'd have to go back and I read so much stuff this afternoon about this that I'm not 100% sure on it, but I'll look in the meantime.
Yeah, I mean, does she strike you as a judge who gives a shit about what the
Well,
rules?
no, she didn't do it the first time.
Right.
The first time she just denied it. Well, she did say, because the Supreme Court didn't grant your motion to disqualify, it's denied. So I guess that was her conclusion of law.
Well, no, I think her original conclusion of law was that the Indiana Supreme Court didn't see fit to booting me. So there you go. Shove it up your ass.
Right.
That was her conclusion of law. All right. So additionally, on May 15th, 2024, the state of Indiana just turned over a new phone extraction that has been conducted this past weekend. Interesting. Whose phone do you think they're extracting?
Right. So that's the part I forgot about it already, that it was only conducted. It wasn't like they're just turning it over. They just did it.
I mean, whose phone do you think that is?
I feel like it's got to be, it's one of the ones that was found on, wasn't there a phone found on the scene that wasn't Libby's?
I don't think so. Not that we know of.
I thought there was a phone that was another phone that was found.
I don't know, but either way.
Jay here. He's an animal.
No, that's all me, baby.
Sure. No, I know it's you. I'm just blaming Jay.
That the dun is amazing. Okay. See what I mean? It's really good. The defense received possession of that new phone extraction less than 1 week before the motion to eliminate hearing was set and needs more time to review the phone extraction data. Based upon a quick review of the phone extraction, it is likely the defense will use the new phone extraction as part of its evidentiary presentation, arguing against the prosecution's motion in limine to not discuss third-party suspects, as it appears that the new phone extraction provides favorable evidence for the defense. Wow.
Oh, please.
All right. But the defense needs additional time to review the entire phone extraction in order to prepare to argue against the prosecution's motion in limine. Additionally, no, Jay was kind enough to drop all the sound effects that I love into my shit. So now I've got them at my disposal, and I'm sure I will use them brilliantly all the time. Paragraph 13. Additionally, the witness who extracted the phone data last weekend has indicated that he will be issuing a report on his findings as well as investigating matters identified by the defense that the defense believes provide important information concerning third-party suspects. All right, so
that's so unusual to me.
It seems like maybe it's like a Messer phone, maybe it's like the one of the Messer phones that we were hearing about, like the Messer phone with the.
It could be, yeah, that's true.
It seems like that would have to be the phone. So the Goldilocks phone, I think, got turned over to the defense's investigator, I believe, if I'm remembering correctly, but there was a second Messer phone that I think that the state had. So I'm guessing, obviously, I'm speculating wildly, but that would seem to fit. And if that's the case, if it is, the Messer phone, well, then I don't know what to tell you other than, oh, somebody killed my sound effects. Did you do that?
I did not. I don't even know how to do that.
Oh, all right, good. I want to make sure to keep it that way. I don't want you to learn that. So somehow blocking my ability to be able to do that. All right. 14, the defense would therefore request that at a minimum, the hearing on that motion to eliminate be scheduled until after the aforementioned report is filed, as it would be judicially economical to hear all the evidence for the motion to eliminate at one time in one hearing, and would additionally prevent the court from prejudging the evidence presented, until all the evidence could be presented at the same time in the same hearing.
Nice.
15, the trial has been continued until October 14th, which should provide an abundance of time to find new dates to conduct said hearings.
I got it, just like poking her.
Yeah.
You got plenty of time, Judge. So
all the time in the world now.
Abundance.
We got all that time, thanks to you, Judge. Since Gull cannot rule on any motions until after she rules on the defense motion to DQ, it would be judicially economical to continue the matter scheduled from May 21 through the 23rd until after Judge Gull's had a chance to review the motion to DQ and issues findings of facts and conclusions of law should she deny the defense motion to have her disqualified as judge on the case. Surprisingly, 17 shocks me to the core.
It can't because she can't do anything. So
17, the prosecution has been contacted and does in fact object to this request.
Oh, and does object.
He does object. He wants to go forward. He's ready.
I read it as
he objects to a continuance of the trial. I object to any continuances. Everything needs to go right now because I'm ready. I'm Nick McClelland and I'm ready.
It seemed so logical that they would not object that I read that in my mind as does not object.
I mean, whatever. All right. So there's that motion.
All right. Now buckle up.
Buckle up. Should we do so? We've got a few.
You got to do what all the people are here for. Just get to it.
The big guy.
Is there anything really? Well, I don't know. Is there anything else really interesting in the other ones?
I mean,
well, I forget.
Like the people like to hear all the shit, man. Like,
so then don't save this one for last because
it's a long mofo, man.
Right. Plus, and we'll probably want to talk about it, and then we'll be like, all right, we're not getting to those other ones.
Yeah, it's definitely an Andy. You know, Andy writes very lengthy motions. He reminds me of somebody that I'm married to and lives in my house. All right, so okay, we'll whip through these next couple.
Oh, that's the state's motion. I didn't even read that one. So
yeah. Filed today, 2:35 p.m. EDT. Motion to dismiss the motion to suppress filed April 11th, 2024. And I will say I have read it. It's short, so it's not lengthy. The other state filing today is a little lengthier. So now comes the state of Indiana by prosecuting attorney Nicholas McClelland and requests this court to dismiss the defendant's motion to suppress filed April 11th, 2024, in that it is too vague in violation of Criminal Rule of Procedure 2.7b. And in support, said motion states the following. 1, that the defense filed a motion to suppress on April 11th, 2024, asking the court to suppress the statements the defendant made while he has been incarcerated in the Department of Corrections. 2, that the defense seems to imply that there are statements made by the defendant while he was incarcerated that were coerced by state actors during a custodial interrogation. 3, the defense fails to put the state on notice which state actors coerced the defendant, fails to outline which statements they are seeking to suppress, fails to state how the defendant was coerced in a custodial interrogation setting, and fails to outline the basis for their motion. Got any thoughts on those failures?
I mean, I was just going to say that this is just basically the state arguing that the defense hasn't even met the initial burden in the motion itself, and that on the pleading it should be dismissed. Now, we did comment when we went over these motions to suppress that we're like typically you would identify the specific, even if it's just by date and time, the specific statement seeking to be suppressed. As far as what state actors, that part I feel like is, that they know, obviously, who is out there and whoever reported the statements.
Yeah, I mean, to me, that was like a lot of words, and really what this sounds like to me is like the famous Joe Pesci, everything that guy just said is bullshit. Like that's basically what his motion's saying. All right, so 4, that under criminal rules of procedure 2.7b, when the defendant files a motion to suppress, the defendant must clearly state the items or statements to be suppressed and the basis for that suppression. Now, in fairness, I was left wanting and a little bit confused as to what statements they were trying to suppress. Remember, we had a very long conversation.
Yeah, I just said that. I don't know
Oh,
if you were.
no, I was spacing out.
Yeah.
Wait, do you like that? Because
I
you
was
do
just
that
gonna
shit to me
say,
all
is
the
that what
time.
I do all the time?
Yeah, all the
Role
time.
reversal.
Role reversal. I flipped the script on you. Okay, so 5, that the state contacted the defense and requested that they fix the deficiencies in their motion, but the defense refuses to give the state any guidance on their motion to suppress and refuses to comply with Rule 27B. I thought that they were like Nick was done communicating with them. Didn't he say that? Didn't he say I thought he said, I'm done talking to these mofos because I don't like them and their big fat liar faces. So I'm done talking to them. That's why that's what I remember. Last thing I heard about Nick with regard to the defense. I don't know, man. Like, I don't know what he's expecting, but like he's made it pretty clear he doesn't want to talk to him anymore. The days of playing nice, which never existed, are officially over. I'd like to see proof that he reached out. Let's see the proof. Where's the receipts, Nick? 6, the defense has failed to outline which statements they wish to be suppressed, who the state actors are that coerce the statements, and the basis for the suppression. Like in terms of the state actors, it's both the COs, correctional officers, and the companions.
Right, and there's no downside to the judge granting this motion. It's not like they're then, not allowed to refile and include more details.
For sure.
And if the judge found this to have merit, what you would expect in a normal situation is for the judge to say that the motion is denied without prejudice, or the state's given, or the defense is giving leave to amend its petition to cure the deficiencies mentioned in the state's motion.
Okay.
Something like that. But either way, it's not like, oh my God, we can't ever bring this up again. You just, might have to refile.
Yeah, no, I hear this. So I'm going to ask 2 judges that I really, really respect a lot what their impression of this particular motion is.
That was wonderful.
Bravo!
I loved that.
Oh, it was great.
Well, it was pretty good.
Well, it wasn't bad.
Well, there were parts of it that weren't very good,
It
though.
could have been a lot better.
I didn't really like it.
It was pretty terrible.
It was bad.
It was awful.
Oh, it's
Get
terrible.
him away!
Hey, boo!
Boo!
Oh my gosh, the buttons.
Wow.
The buttons.
I mean, the buttons are so fun. And that's the Muppets. It's the
The
judges.
Muppets, right.
Yeah, I mean, come on, dude.
I said Kermit. He's a Muppet.
It's true. Kermit is a Muppet. All right, so let's move on to all right, this is a 5-pager, and I will tell you, I'm gonna go down. It's signed off by Nick. There is 0 chance that Nick drafted this.
Where you're saying it's better than you're used to?
I shouldn't say 0. I'm gonna say there's a 1% chance that Nick actually drafted this motion.
All right, well, let's burn through it so we can get to the big guy.
All right, the big guy. All right, so this was again filed today, 2:35, simultaneous to the other filings. State's response to defendants or defense's 4th motion for a Franks hearing. Now comes the state of Indiana, by and through Nick McClelland, and files its response to Richard Allen's 4th Franks motion based on newly discovered evidence and request for hearing, referred to by the state as the defense's 4th big pile of shit. That in this previous
That'd
3
be hysterical if they said that.
That's what he wants to write.
Right.
Okay, that as in the 3 Franks motions filed by the defense, this 4th motion illustrates a complete misunderstanding of the ruling in Franks v. Delaware and the purpose of a Franks challenge to a search warrant. The defense makes the same allegations in this motion as it has in its previous three motions, that Sheriff Tony Liggett failed to advise the judge of material facts, and that without these omissions, the search warrant would not have been issued. The defense consistently in its 3 previous Franks motions it should be motions, right? Have misstated and mischaracterized facts surrounding this case. That trend continues in this most recent Frank's motion. So the defense's motion in paragraph 25 contains a list, A through L, of information the defense asserts should not have been omitted from the probable cause affidavit for the search warrant. However, the information is either irrelevant for probable cause purposes or wholly inaccurate. The state has addressed most of these inaccurate facts in previous replies to the Frank's motions. The new topic the defense focused on in the fourth Frank's is the AT&T pings. The defense includes in this motion information about pings generated by AT&T on February 13th, 2017 through the 14th of 2017. The defense also includes statements made by Sergeant Blocker when he was consulted by Steve Mullins about the pings. The information in the motion show that the defense does not understand the information contained in the pings and then exacerbates the problem by mischaracterizing the statements by Sergeant Blocker. Further, contrary to what the defense motion states, the defense have known about the pings well before April 26th, 2024 discovery disclosure. What do you think of that?
Well, we know that they said that it was had already been turned over, and then that they returned it over and properly identified it, or I won't say properly, specifically identified it in a separate disclosure, because the defense was arguing you just dropped, all this shit on us without any clear way for us to find anything or determine what's there. So I think that's what they're saying, is that it was already there. They just didn't find it.
Right. I mean, they're basically calling Brad and Andy caveman lawyers, that you don't understand our modern world. You don't know what the fuck a ping is. Pull your head out of your ass. You've had this for months. You just didn't know what it was. You know, I mean, that's basically what they're saying. When AT&T pings a phone, they will send a signal from the tower nearest the cellular device to that cellular device. From the time it takes the signal to reach the device and get back to the tower, they will determine a location of that device. The location can be accurate at times, but can be completely inaccurate at times. Again, this falls right into your entire thing. Like, Nick McClellan has just assured himself that he can never use tower pings because every defense attorney that's worth his shit is going to pull this motion up and say, hey, Nick, what's changed, buddy? You can't say that it's like absolutely conclusive in your own words. You said it's sometimes it works, sometimes it doesn't.
I'd surely be wanting to either, get a stipulation to this motion or call him as a witness that the official office understanding is this is unreliable evidence.
Right. Hot garbage sometimes.
I mean,
it's hot garbage when we're defending it. It's like just infallible when we're using it to convict somebody. Just so you understand, Judge, that's how it works with this thing. If the tower cannot make cellular contact with the device, then the ping data will show a historical data location. That means the service provider will show a location from the historical data collected from the device. Repetitive much? It is the last longitude and latitude collected from the tower when it had good service with the device. So, I mean, their argument is that a phone that in theory never moved had good service at one point, but then at 4 a.m., which is decidedly inconvenient for the state, it's got terrible service.
Terrible service.
I mean, maybe they turn the towers off.
Yeah, and the
hey,
defense
it's 3 a.m. Let's
the
turn
defense
it,
are
everyone's
cavemen.
sleeping. We'll turn the towers off just for a couple hours. They won't know.
And it's the defense that can't understand how technology works.
I mean, I guess.
Yeah.
They are caveman lawyers. So that means the service provider will show a location from the historical data collected from the device. It is the last longitude and latitude collected from the tower when it had good service with the device. That is not a pinpoint location. The location given comes with an inaccuracy range somewhere from 400 meters up to 25,000 meters. Those inaccuracy ranges can differ based on several factors. A tower can lose contact with the device because the device runs out of power or because the device loses cellular service. Law enforcement uses this as a tool in certain cases to attempt to locate a cellular device. It is not always accurate. It is not always an accurate way to locate a device, but can be used as a tool to help determine the location of a device. In our current case, when the girls went missing, law enforcement contacted AT&T and asked AT&T to ping the cell phone of Libby German. This was done in an effort to locate the girls. The pings came in from AT&T every 15 minutes. That means that AT&T would send an email to law enforcement every 15 minutes showing the ping results of pinging Liberty German's phone. Each ping will give a longitude and latitude of the device with a radius estimate and the source of that data. The location data is not a pinpoint location, but can range in accuracy based on the radius estimate and or based on the contact that the phone had with the tower. If the phone did not have contact with the tower, the longitude and latitude is based on historical location data. In those cases, there will not be an inaccuracy range because the location is based on historical data and not live data. So the defense deposed ISP Sergeant Greg Edwards on February 27th of 2024. The defense presented the AT&T pings to Sergeant Edwards for his review. Sergeant Edwards explained the data in the pings to the defense at that time. Sergeant Edwards stated, quote, "So those emails begin coming in, and you've got this text block that has to do with, again, the case ID or the number that they've assigned to it. AT&T is assigned to it. You've got the mobile number, so the phone number that is assigned to that device that they're currently pinging, we can see the last four digits here. It's 7599. Did you understand what that meant?
Well, I know what you're talking about. I was just going to say they do, when they give you those pings, it does give a range of how close. So you could get one in 15 minutes that says it's like 10 meters accuracy, and another that says it could be up to, like a different number. So I guess maybe what they're about to describe here is that the defense actually did misread something. I don't know. Keep going.
All right. So, okay. So the confidence level they might put in whether or not was a high confidence location for it, meaning that they had a lot of good information coming in from that device and from the tower network to say it's real close within this area. They might say it's a low confidence area, meaning that it's quite large. Or here they aren't listing a confidence area. And I'm assuming he says, or as here, or here, talking about this particular situation. They aren't even listing a confidence area. So I don't know what to say about that confidence area. Sometimes the confidence level they'll have is a size in meters. Right. So say that it's within 1,000 meters. We believe the device is somewhere within 1,000 meters of this geolocation. So that's what they'll list in the confidence area. Then the latitude and longitude. So they give you a latitude and longitude coordinate so that you could plot that on the map. And then radius, location accuracy unknown. So they didn't give it they didn't give us. That's why there's no confidence level. There's no number of meters from that geo point that's associated with it. And then data source is telling us that that's coming from historical records. That's not coming from the device, like live and acting, live and active. They're providing information that coming from. This is
a deposition. So sometimes people,
make word salad.
Yes.
Make word hard.
Okay. So they're going back and they're collecting information from the historical called detail records. So Edwards later says, do you have something to say?
No, go ahead.
Okay. Edwards later says, quote, with AT&T, part of the reason why it says historical here is that they say, all right, we're going to ping that phone, but they can't get to the phone. Well, then they'll use the last known location from the historical records. So that is different than the live ping. It's going back to the historical records saying we can't find the phone right now, but here's what we know. Here's where we know it was last. Okay, so, and that's end quote. So they're not breaking it down for us. I'm assuming that he's talking about the 4 a.m. ping.
Right.
That
He's
4 a.m.
saying,
ping did not have like any kind of real.
yeah, but what's strange is that the ones in between it, we'll have to see it because it doesn't sound exactly right, but who knows? But why would it have in the hours between just said we can't reach the phone? We can't. Why isn't it just defaulting to historic data on all those other times?
Right.
So, but so Bob and I can't really, speak to this, and eventually someone who can will.
Yeah,
In this
somebody
matter.
who's seen the reports.
Right.
Right. The ping emails collected all show historical data. That means
All?
the ping emails collected all show historical data. That means
That makes no sense because we're pinging it at some point live.
if they're saying all, that means that the initial ping that put the girls on the bridge is also historical data. That means that the tower could not find the phone at the moment the ping was initiated. So it just gave the service provider the historical data location. That doesn't mean the phone wasn't in the area or that the phone wasn't in working condition. It means that the tower could not contact the phone. That historical data continues through all the pings. So Edwards did his very best to explain to the moron defense attorneys who just don't understand anything, the information on the ping returns. He attempted to explain to them how pings work, what the longitude and latitude means, and what historical location means. The defense still doesn't understand how to interpret the pings from AT&T. Wow. The pings from AT&T show the location of the phone through historical data. That means the tower is not contacting the phone. Okay. The defense then goes on to mischaracterize Sergeant Blocker's statements contained in Steve Mullen's report. Blocker reports that from his evaluation, the last contact the phone had with the cellular tower was 5:44 p.m. on February 13th, 2017. Okay. Is it historical data or not?
If he writes it like that, there's the rest of this little paragraph, but writing it like that specifically says that the phone had contact with the phone, made contact. That sounds live.
But he said that historical data continues through all the pings.
Well, maybe if we read the
pings.
Maybe if we read the next sentence, somehow that'll
maybe it'll cure itself. They'll cure it. The defense then goes on to mischaracterize Blocker's statements contained in Steve Mullen's report. Blocker reports that from his evaluation, the last contact that the phone had with the cellular tower was 5:44 p.m. on February 13, 2017. The records from AT&T show there was no contact with the tower since then. So all but one. Is that what he meant to write? All but one.
Yeah, seems that way.
Or historical data.
I don't know what time they started the pinging.
I think right around that time. I thought they put the time up here. No, they just said, well, we know that they don't go to law enforcement until after 5. So it couldn't have been until after 5.
So it might have been all the pings.
Might have been all the pings. In which case, how are they saying this? How are they saying this? That the last contact.
Well, that's what we're saying. If it was after 5:44 p.m. that they started getting the pings.
Yeah, unless they're saying that this wasn't a ping, right? That's what you're saying.
Right.
It wasn't a ping, that this was just something that just bounced through the tower and showed that Libby had sent something, maybe a snap or whatever, some kind of activity that pinged off the tower, absent AT&T pinging them every 15 minutes. All right, the records from AT&T show that there has been no contact with the tower since then. From that information, he determined that the phone was no longer in the area or no longer in working condition. The defense wants this to mean the phone is not in the area from the evening of February 13th, 2017 until the morning of February 14th. That is not what it means. How do you know what it means? Were you there, Nick? Was Nick there? How would Nick know that? Because Nick says so. Is that how we know? Because Nick says.
Right, because it sounds like the sergeant says it could be because or
Right, but
so.
Nick says that's not what it means. So as far as I'm concerned, I mean, for Nick, this is a case closed. That's
Miss
it for Nick.
sound.
Okay, so it means that since the pings were only showing the historical data location, the phone was not having contact with the tower. Sergeant Blocker explained that that could be because the phone was not in the area, but it could also mean the phone was not working. This is consistent with the pings collected from February 13th through the 14th of 2017, that the pings are given an estimated longitude and latitude based on historical data, location information, live, not live pings. All right. The information is consistent with the information in the probable cause. Okay. The information that we have is the girls were dropped off the trails around 1:30 on February 13th of 2017. That at 2:13, their kidnapper ordered them down the hill. There is no evidence that the girls were ever taken from the area or that they were brought back to the area later to be murdered, aside from maybe the lack of blood at the actual crime scene where the girls are discovered. Maybe that is some kind of indication that they were moved.
Might indicate
there.
something like,
Every indication is that they were ordered down the hill and then murdered soon after. The historical location data from the AT&T pings does not mean that the phone was not in the area during the evening of February 13th until the morning of the 14th, but it could. It could. It could mean that. It is another example of the defense taking information and stating that it means something that it doesn't. This is consistent throughout all their Franks motions. The state has outlined the test used in Franks in its prior responses. In order to have a Franks hearing, the defense's attack on probable cause must be based on deliberate falsehood or acts of reckless disregard for the truth, and those allegations must be accompanied by an offer of proof. The claim should point out specifically the portion of the warrant affidavit that is claimed to be false and should be accompanied by affidavits or sworn statements or reliable statements of witnesses. The defense must show that there is an inaccurate or omitted. The defense must show that there is inaccurate or omitted information, and that probable cause is lacking if the omitted information is included. Franks v. Delaware. Herein, the defense claims omissions, if included, would negate probable cause for the search warrant of Richard Allen's residence. The defense has not met its burden. The omitted information from the AT&T pings does not negate the fact that Richard Allen places himself on the bridge at the time that Liberty German took the video of the bridge guy who ordered the girls. What?
I'm sorry. I have since day one, when they talked about that very first statement that Richard Allen made, that was not, I do not think in good faith, that was him saying I was on the bridge from 1 o'clock until 3 o'clock, as opposed to I was on the bridge between 1 and 3. Like not from 1 to 3. You know, I don't know.
Yeah, no, I'm with you. Like, but I haven't seen them. I haven't seen them. Like at this point,
what the guy wrote down, like which was like he was on the bridge between 1 and 3. But I think it could very easily have been like that's my range. I was there.
Well, that's what I'm saying. Like if I'm devil's advocating against that position, then I would think that if they had something definitive that Richard Allen was abundantly clear that he was there from noon until 1:30 and then gone to where they felt comfortable enough to like put it out there, that they'd be putting it out there. So it's telling me there's contradictory like time frames, like from Rick Allen. In his defense, it was 5 years in between.
Right. And it was a range. He was giving a range. I was there between, sometimes.
But why did he start it? Like he didn't start it from noon till 3. He went from noon to 1:30 and then from 1:30 to 3.
I mean, I was just saying numbers, so I don't know. Maybe.
I don't know. Like that's what I understand the two ranges to be: noon to 1:30 and then 1:30 to 3. Which I don't know is like which one was made when. And I don't know if Doolin wrote down, like actually kept notes. Like I know he didn't record it. There's no recording of Allen's first like statement to him. So, like if there is writings, that's what we're going to be left to.
Is this the last page?
Yeah, it is. Further, Richard Allen admits that he was wearing clothes matching the clothing the bridge guy was wearing. That along with other eyewitness testimony and the other evidence gathered establishes probable cause that Richard Allen is bridge guy, and he is the one who kidnapped the girls. Wherefore, now comes the state of Indiana, and they file their response to the defendant's fourth motion of Franks. It would ask the court to find the defense has not met its burden to warrant a Franks hearing. The motion contains nothing more than their beliefs about what AT&T pings mean, without an understanding of what the data means. Sheriff Tony Liggett did not intentionally or recklessly omit evidence or lie about evidence in the probable cause affidavit to support the search warrant in an effort to mislead the judge. The facts in the affidavit are true and accurate and are supported by evidence collected in the case. Sheriff Tony Liggett relied on that evidence when drafting the affidavit for the search warrant as the best reliable information known to him and related to Richard Allen at the time of the request. There are no inaccuracies or omissions in the probable cause for the search warrant. There are of material nature. And the defense argument that law enforcement dishonestly is pervasive and relates back to the affidavit in question is not supported by sworn statements, affidavits, or other reliable statements.
All right. So what the state did here is they raised what we call in the law a question of fact. They spent a lot of time disputing what the pings mean. That is precisely that this motion establishes the need for a hearing. So the judge has to assume, for the purposes of deciding whether there should be a hearing, that the ping information is the way the defense presented it, that they'll be able to prove that up at a hearing. If the judge were to decide, even if everything the defense says is true, that doesn't change anything, well, no hearing. But she surely cannot, under the law, doesn't mean she won't, cannot say, well, I think the state's explanation of the pings makes more sense. Therefore, they haven't met their burden. Therefore, no hearing, which is precisely what the state just asked the judge to do. So again, to kind of restate it, the state raised what we call an issue of fact, and issues of fact need to be decided at a hearing.
Yeah, I agree. I mean, I'm not optimistic that she's going to grant a hearing on this.
Well, the state did its best to make it evident that a hearing is required, unless, again, she were to say, accepting the defense's version of the pings is true, I still don't think that affects the probable cause.
Right. All right. So,
all right, here's the big guy. Before we get into it, is there any questions that we need to address of anything that we've done thus far?
I don't see anything starred. All
right.
And our mods have not put anything up for us that they felt was something that we should address. Because I'll tell you flat out, y'all, I cannot follow the chat. It's too much for me to follow.
And I can't if I'm listening to you, so I'm not either.
I'm reading, so I'm not obviously looking at the chat. I mean, I'll go through and scroll through it occasionally. I always look at the starred stuff. Hint, hint. All right. So defense's second verified motion to disqualify the judge and request for findings of fact and conclusions of law upon denial of this request, if this court denies this request. So come now, Rosie and Baldwin, pursuant to 2.4 of the Indiana Rules of Crim Pro, and they move for a change of judge from Judge Frances Gull or her recusal from this cause. In support of said motion, they swear and affirm as follows. So first, they're going to start off the legal standard here. The filing of a motion for DQ and or request for recusal strips the court of jurisdiction to decide on any matters until a ruling on the DQ motion occurs. Lucas v. State. Like, do you want to talk about that? Because like Allie read this, she's like,
there's no law. Where's all the law?
And I was like, wait, there's some law. There's law.
Well, that one we discussed in the motion to continue, that is an accurate statement of the law, that the judge, like you told the people earlier, The judge's workaround is to deny this quickly and before the 21st, and then she can proceed on the 21st. Otherwise, she cannot.
Okay. Paragraph 2, pursuant to ICR of procedure 2.4b, quote, the state or the defendant may request a change of venue from the judge only for bias or prejudice. This motion must be accompanied by an affidavit signed by the defendant or prosecuting attorney. The affidavit must set forth facts and reasons for the belief that the bias or prejudice exists. If the defendant signs the affidavit, the defendant's attorney must file a certification that the attorney believes in good faith that the facts recited in the affidavit are true. Now, obviously, Alan's lawyers are preparing this, right?
Well, right. But in this case, they didn't do it that way. They put all of the facts in this, and the affidavit merely says, I have read this and everything in here is true.
Right.
So there's not anything else. This is it.
Correct. So in bold, the court must grant the request if the facts recited in the affidavit support and this is bold and italicized for emphasis, a rational inference of bias or prejudice. Put it another way, the facts contained in the affidavit must show that there's a reasonable basis to question the judge's impartiality towards Richard Allen and his defense team. This word is brutal. Concomitant. How the hell do you say that? Concomitant. Okay, I think that's it. Which I think means like goes along
Aligned with.
Yeah,
right.
aligned with. With Indiana Criminal Rule 2.4b is Rule 2.11 of the Indiana Code of Judicial Conduct, which requires a judge to DQ himself or herself when the judge's impartiality might reasonably be questioned. Such is the case in this cause of action. The rule on disqualification and the canon on recusal both adopt a threshold of reasonableness. Would an objective person have a reasonable basis doubting the judge's impartiality?
And I'm going to focus on this structure of the words here. Would an objective person have a reasonable basis doubting the judge's impartiality? Objective. Now, some might find most of us in here are not objective. You know, if you've got, if you firmly hold a position, and that becomes a question, as you'll see later, because the defense relies a lot on, well, there's been plenty of members of the public who've been writing to the judge challenging her impartiality.
But they're not objective either. Like I need to go to like
I just said that.
Yeah, like we need to go to some dude in California that's surfing and say, "Hey man, come here. I'm going to read through a list of shit and I want you to tell me if this was your judge, say you got arrested for stealing a car and this was your judge and this is the shit she's been pulling for the last like year. Do you think that this judge is biased?" And that guy would be like, "Oh, I don't know, man. So read it to me, dude." You know, it's like we need somebody who knows nothing about this case, has
that they can know something, but they've got to be objective, you know. And just to answer, while we're paused, I just want to answer this anyway, since it's up here for Renee S. And we don't forget that, yes, that's, as far as I understand it, there's a longer recording. And of course, that is discoverable to the defense, and they surely should have it by now.
Yes.
But
yes.
I know there were issues before where they were looking for something about the entire recording. So I don't know. But yes, it is absolutely discoverable. It has to be turned over.
Yeah, and I'm assuming that has, but like they would be screaming about it. Like if they didn't have the full bridge guy video, like we'd be hearing about that in every single like filing that they ever file regarding discovery. So I'm assuming that they got that. All right. So the comments to Rule 2.11 of the Indiana Code of Judicial Conduct provide additional guidance. 1, under this rule, a judge is DQ'd whenever the judge's impartiality might be reasonably questioned, regardless of whether any of the specific provisions of paragraphs A1 through 6 apply. In many jurisdictions, the term recusal is used interchangeably with the term disqualification. 2, a judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to DQ is filed. And then 5, a judge should not disclose on the record information that the judge believes the parties or their lawyers might reasonably consider relevant to a possible motion for DQ, even if the judge believes there is no basis for the disqualification. And then paragraph 5, the test, quote, under the canon is whether an objective person knowledgeable of all the circumstances would have a reasonable basis for doubting the judge's impartiality. The question,
so knowledgeable of the circumstances is important. They just have to be objective.
Right. So the question, and so the real question is, and just so you guys understand, and I know I brought it up already, but I'm going to restate it in case you're late to the game. In Indiana, the judge who is being asked to either DQ or recuse themselves is always the one who decides this motion. Like in Illinois, if we're going after a judge to try to get him off our case, and we're doing it because of cause such as bias, what happens is they kick it up to the chief judge. The judge assigns another judge, and that judge hears the argument and makes the decision whether or not he thinks his fellow member in a robe is biased,
or that there's the appearance of impartiality.
Right. Which is it seems like it's hard to get another judge to roll on another judge, but it's like I'd rather have that than having the judge who's sitting on the trial and just refuses to let go of it for whatever. Like, I still don't get why she wants to sit on this case so much. I don't get it. Like, I don't understand her position with it. Seems like her life would be way happier not having to deal with Brad and Andy. It's like, and
less of a risk of any appeal issues and all the things and such. But go on, because it's a long one, so we can't keep talking.
Wait, I'm already on page 3 of 40.
All right, you're doing
We're
great.
Flying through it. The question is not whether the judge's impartiality is impaired, in fact, but whether there exists a reasonable basis for questioning a judge's impartiality. So that's Tyson v. State. The opinion of Chief Justice Shepard recusing himself from consideration of a petition for transfer.
So I'll let you know what happened there, because that was the case that Bob actually said to me, wait, there is a case. So I was like, oh yeah, I forgot there was an early cite. So I read this case. This case deals with, so they're at a, like a function, some sort of function, and the judge's wife bumps into a female lawyer in the bathroom. And the judge tells that lawyer, you really need to get your shit together when it comes to appeal issues. I think it was an appeal on a denial of bond, because your argument that, hey, I forget what it was, something like, you can arrest me if this guy doesn't show up, that's not gonna fly. So the judge on his own recused himself, considering that to be the equivalent to ex parte communication, even though it wasn't him directly, even though it wasn't initiated by any of the parties, but initiated by his wife. And he chose to not be involved in the case.
Right. All right. Paragraph 6. The accused has a federal due process right to an unbiased judge under the 5th and 14th Amendments to the U.S. Constitution. Judicial bias is one of the narrow classes of constitutional violations that implicate structural error.
The other being denial of your right to counsel of choice, which we have dealt with in this case.
And tell them what structural error is, babe.
So structural error just means it, and they're going to kind of get into it as you read down below, but actually they do. So I'll just let you keep reading. Okay.
Cases of judicial bias involve a denial of the most fundamental constituents of due process. So fundamental that a conviction in their absence is indecent, even if the defendant is plainly guilty.
And there's your example of what of it being structural. Doesn't matter if you mess this one up,
right?
It's going back. It's canceled out.
Right. You guys get that, right? So like they could have all the evidence in the world, smoking gun evidence, like you couldn't believe. And if there's structural error, it's going back for a retrial.
Where normally, and also they get to it in this next sentence, but normally it would be a harmless error analysis. So if someone's plainly guilty, that's one of the biggest things the court relies on. They're like, well, this was wrong. This was wrong. The judge shouldn't have done that. The prosecutor shouldn't have done that. But the evidence is overwhelming that this man is guilty. So it's a harmless error.
Right. All right. So, and this is what Ali was talking about. Structural errors render a criminal trial fundamentally unfair and are not subject to harmless error analysis. The preamble to the Code of Judicial Conduct provides that judges, quote, should aspire at all times to conduct that ensures the greatest possible public confidence in their independence, impartiality, integrity, and competence.
I mean, I think we should read that again for Judge Gull.
All right.
Are you listening?
So the preamble to the Code of Judicial Conduct provides that judges, quote, should aspire at all times to aspire at all times to conduct that ensures the greatest possible public confidence in their independence, impartiality, integrity, and competence.
So that's it. Close the thing. It's over. What should the judge do? She should recuse herself.
Right. But,
I'm just kidding, everyone. He's still going to read the 40 pages. I'm just saying. That's like a drop the mic, quote there.
It says it all.
It
says it all. Like if it even smacks of impropriety, you got to go. Got to go.
Just like make decisions that, put all the confidence the public could have. And right now, this is not it.
Right. I mean, like we know that at least a large portion of the public is not showing much confidence in Gull on this trial. I mean, that's facts. That goes to the emails. I mean, they're certainly biased, but bias is an opinion.
I'm sure they're going to quote some of them. And I do remember reading somewhere, someone's like, I'm a paralegal. I'm looking at this very objectively, and I still feel, X, Y, and Z, where there's other ones that they just, will Allie get rest? Tired. Allie yells at, wow, Jay. That's a bunch of bukkake.
Oh my God, you had to bring it up. Like the Delphi world may not know of the bukkake scandal that has reared its ugly head.
Well, then they have to start watching Jay and Not So Silent Bob's coverage. And
I mean, if you love great trials and fascinating procedural shit
and boy giggles,
and you're not watching Karen Reed's trial, I don't know what to tell you. You're whiffing big. That trial's like it's the other trial where the defense put out their theory way before trial, and both worlds like collided and caused like huge warring factions online. It's the only two cases that I know of like that. All right, so now we're going to get into the receipts. These are all the things that.
Well, first it's a list, and then each one separately with details.
Right. So Allen incorporates his first verified motion to DQ filed January 28th of 2024 as if fully set out herein. Okay. 8, after the Supreme Court quickly reinstated the defense following oral arguments on the same day, the Indiana Supreme Court did not grant Allen's request for Judge Gull to be recused based upon the limited record set out at that time by Allen's appellate counsel.
Yeah, that paragraph seems like it's missing the point, which was she denied the motion on that day.
Right.
It just, yeah. I read it twice, maybe 3 times to figure out if it was.
Right. So on January 28th, 2024, the defense filed its motion requesting Judge Gull be DQ'd, knowing that the Indiana Supreme Court was not aware of all the reasons Allen could cite that showed a rational inference of bias. 10, but why? Why didn't they do that? Like, why didn't they do it then?
I was thinking the same thing, but
I mean, like I'll tell you, like I was there and like I walked out and I told Kara, I'm like I nailed exactly what they were going to do. I'm like, they're going to restate Baldwin and Rosie. They're not going to grant the other 2 things. The 70-day, they don't need to do shit with. They can file it on their own. And the other thing, Gull was never brought up ever. They didn't I don't even know that her name was mentioned in the entire hearing at all.
So they focused more on, on getting the lawyers back on their biggest arguments. I don't think that they had much confidence, I guess, that the judge was going to do it, but you know.
Yeah, and like my mind was spinning all over the place. I'm like, is somebody from the Supreme Court going to give the judge a call and say, "Hey, we gave you a pass on this one, but when they file the inevitable DQ motion, probably be the right move for you to DQ yourself." I obviously, if that did happen, she's like, pound sand, not doing that. I don't like. I just don't know why she wants to be on this case so badly. 10. The defense cited 18 reasons for Judge Gull to recuse herself in that January 28th, 2024 motion. On February 6th of 2024, before finding out exactly why Scoyne or the Indiana Supreme Court rejected Allen's request to have her removed, Judge Gull denied the defense's request for her to be removed. Footnote 1. Supreme Court of Indiana's opinion detailing the reasoning for not taking Gull off the case was issued on February 8th, 2024, and certified on the 15th of 2024. So so paragraph 12, Judge Gull's one-sentence denial of the defense motion to have her disqualified stated, quote, "The court, having defendant's verified motion to DQ filed January 28th, defendant's affidavit filed the 28th, and the certification of Richard Allen's attorneys filed on the 28th as well, under advisement and having considered the pleadings, now denies the verified motion to DQ without any hearing," quote, in bold, rather, "as the Indiana Supreme Court unanimously denied the defendant's previous request on January 18th, 2024. So 13, had Gull waited only 2 more days before ruling on the defense motion to have her DQ'd, she would have had the benefit of learning exactly why the Indiana Supreme Court did not disqualify Judge Gull. On page 16 of its order reinstating Baldwin and Rosie, the Indiana Supreme Court stated that Allen, through his attorneys, did not, quote, identify anything that she has done that demonstrates that she isn't impartial. And that's their opinion, page 16. 15, at the time the Indiana Supreme Court issued its opinion, the court did not have the benefit of reviewing the 18 reasons the defense cited in its January 28, 2024 filing, which the defense claimed supported a showing of Judge Gull's bias. Certainly, some of those 18 reasons were included in the Indiana Supreme Court's opinion as, by themselves, not being enough to cause Judge Gull's recusal. However, many of the examples of the bias identified by the defense in its January 28, 2024 motion were not cited by Allen's lawyers in their request for Judge Gull to recuse herself. In other words, paragraph 16, Judge Gull's use of the January 18, 2024 Supreme Court ruling as a sort of blanket immunity to support her decision not to DQ herself was wrong, and that the Indiana Supreme Court's February 8th opinion leaving Judge Gull on the case was clearly based on a very finite set of reasons argued by Allen's appellate attorneys, and not the longer list of reasons articulated by Baldwin and Rosie in their motion to have Judge Gull DQ'd. Judge Gull ignored that longer list and instead erroneously used the Supreme Court's ruling as her reason to remain on the case without any legal analysis and before reading the Indiana Supreme Court opinion. 17, the defense is requesting that if Judge Gull does anything but recuse herself from this case, that she issues findings of fact and conclusions of law that support her decision to deny the defense motion rather than a one-sentence order summarily denying Richard Allen's request. 18, in addition to the reasons cited in his January 28, 2024 motion, Judge Gull has revealed a rational inference of bias towards the defense based on the following. You ready for this long list? It's a long list.
Well, I hope it rounds out the number one that I see, which is all of the things that she put in the order relating to the sanctions and the earlier order.
I know. Yeah, I
About
just
their
realized,
being
I've been
incompetent.
I've been live for 12 hours today. 12 hours. No, that's not true. I took a break. I took a 2-hour break. All right, let's go through this list. A, Judge Gull engaged in ex parte communications with the state of Indiana. B, Judge Gull interfered with a properly subpoenaed defense witness. C, Judge Gull treats the prosecution more favorably than the defense. D. Judge Gull engaged in the act of prosecuting Richard Allen by inviting the prosecutor to file pretrial motions seeking the limitation of evidence of third-party culpability and also forecasting the outcome of such a request by the state. E. Judge Gull continues to make disparaging comments about defense counsel in open court and in orders issued by said court.
Oh, yeah, there it is. Okay.
F. Judge Gull's handling of defense pleadings versus her handling of prosecution pleadings. G. Judge Gull placed blame on defense counsel and its staff for administrative failures in maintaining confidentiality of ex parte defense filings, whereas evidence revealed that failures were on the court side of the filings. H. Judge Gull failed to conduct her own internal investigation into allegations of leaks coming from her own staff, while facilitating contempt proceedings against Richard Allen's chosen attorneys for leaking confidential information related to this case. I. Judge Gull effectively denied Richard Allen his right to a speedy trial by not requiring the prosecution to follow the same time restrictions at trial as she was forcing the defense to follow, which forced the defense to seek a continuance of the May 13th, 2024 speedy trial date. All right, so now they're going to break down each of A through I. So ex parte communications and interfering with defense witnesses. So 19, Judge Gull participated in ex parte communications. Ex parte means like she was talking to one side without having the other side there. Judge Gull participated in ex parte communications with the state of Indiana through its witnesses to the detriment of the defense. 20, on April 5, 2023, Richard Allen, by counsel, filed his emergency motion to modify safekeeping order based on the conditions of his confinement in Westville. 21, on April 14th of 2023, Judge Gull entered an order stating the Indiana Department of Corrections was authorized to move the defendant within the DOC to accommodate his medical and physical needs pursuant to medical directives by DOC physicians, psychiatrists, and psychologists. 22, on May 4, 2023, Mr. Allen, by counsel, filed his motion to reconsider and request for due process hearing, which the court set hearing for on June 15, 2023. In preparation, paragraph 23, in preparation for the hearing, the defense served a valid subpoena on witness and Westville inmate Robert Baston to appear for the June 15, 2023 hearing. 24, when a deputy from the Carroll County Sheriff's Department went to the Westville Correctional Unit on June 14th to transport the inmate to the hearing, the inmate became uncooperative. Carroll County Chief Deputy Tobe Lazenby contacted Gull about the situation, and Gull told Lazenby to leave the inmate there if he did not want to come to the hearing. Tobe Lazenby was the first witness called by the prosecution at the June 15, 2023 hearing, and certainly will be called as a witness at trial. Yet Gull and or her staff communicated with this prosecution witness the day before his testimony without the full disclosure of said communications to the defense. Additionally,
technically, it's an ex parte communication. It doesn't have to be even about the, about the case. But I mean, it's sort of a special circumstance because the guy's dealing with transporting witnesses to a case that this judge is hearing, so.
Right. Okay. 26. Additionally, Liggett, who was a witness at the June 15, 2023 hearing, and will be a witness when this matter goes to trial, issued a report in which he stated, quote, on the 14th of June, 2023, communication with the court was established by Sheriff's Major Chief Deputy Tobe Lazenby, where Major Lazenby was advised by the court to disregard any further efforts to retrieve inmate Baston from the Westville facility, emphasis added. 27, on June 14th of 2023, Gull sent an email to the party stating, quote, FYI, the Carroll County Sheriff Transport officer went to Westville to pick up the inmate requested by the defense team per subpoena. The inmate refused to come out of his cell and demonstrated an ability to fight if forced. Is that what he did? He demonstrated an ability to fight. The transport officer stood down and has left the facility to return to Carroll County without said inmate. I have asked for a formal written report on these activities, which I will provide to you all upon receipt. So 28, what Gull failed to tell the defense in that email is that she was the person who used her authority as judge to direct Carroll County Sheriff's Department to ignore a valid subpoena of a defense witness scheduled to testify at an important hearing on behalf of the defense. 29, it is not unusual for those incarcerated not to cooperate when being transferred from one facility to another when presented with a subpoena.
Here's another little dig. Dig
Little
alert. You need a little dig sound effect.
Or like a dig emoji. Let me see. Let me see if I have any good dig noises.
That's all right. Read the people the footnote.
Say hello to my little friend.
All right. Judge Gull has detailed on more than one occasion her vast experience on the bench. It would be surprising if this situation has not occurred in her tenure on the bench. Dig.
Say hello to my little friend.
All right.
I reject that one.
What? That's Scarface, man.
I know, but it doesn't. It's go on.
Oh my
40
God.
pages.
I couldn't think of something. That was so spot on. All right. However, the lack of cooperation of an inmate is not a legal justification for a judge to direct the IDOC or a county sheriff transport officer to simply ignore a valid subpoena. 30. And by the way, we're on page 11, so there's only 20.
You're doing good. Yeah, no, we're making.
I'm getting through it. I'm like fighting to keep my voice. 30. The proper method for a judge facing that situation would be to underline, bolded, not communicate in an ex parte fashion with witnesses who are involved in the case. Rather, it would be to contact the attorneys for both parties, prosecution and defense, explaining that the court has been informed that there's a potential problem with the transportation of a witness from the IDOC, and that the court will not talk to the state of Indiana without talking to both sides. Then, after both sides are engaged, to work on a solution. If the defense still wanted the witness to attend the hearing, then law enforcement would still be required to use whatever means necessary to transport the inmate, unless the state of Indiana filed a motion to quash the subpoena, which was granted by the court. And just for the record, Baston didn't want to come because he was afraid that there'd be hell to pay when he got back.
Right.
After he testified about how shitty they treat him over at Westville, including beating him pretty severely, ribs breaking, all like Monica Wallace watching apparently. I don't know. So after the June 15, 2023 hearing, Judge Gull denied Mr. Allen's motion to reconsider, stating, quote, the evidence presented demonstrated at the hearing on the defendant's motion to reconsider did not support many of the allegations advanced by the defendant counsel. In fact, the evidence presented demonstrated the defendant is treated more favorably than other inmates housed at the Westville Correctional Facility, end quote. This is disingenuous, given that Judge Gull prevented the defense from presenting the very evidence she said was lacking. Can I play my say hello to my little friend clip there?
Nope.
Oh,
Nope.
Wow. 32. Any perception of Judge Gull's bias was supplanted with proof of actual bias when Judge Gull denied Mr. Allen's motion to reconsider, claiming a lack of evidence when she prevented Mr. Allen from presenting the testimony of Mr. Baston. All right. 33. Communicating with the state's witness in an ex parte fashion provides a rational inference of bias.
So there's where I would have liked to see a cite. And technically, they could have cited that case that they cited in the beginning, because that's exactly what happened there. And they literally said that, any ex parte communication there's a rational inference of bias from. So,
yeah.
Although it's a different factual situation, and I'm sure there is another case that, speaks to that issue. But there was one of the places that I'm like, can we have a cite? You're saying it as though that it's law, and you're not citing the law.
Allie wears the pants. Next question.
Was it right? I'm like, what was that a question?
It's a question, apparently. 33. Communicating with the state's witnesses in an ex parte fashion provides a rational inference of bias. 34. Issuing a directive for a state's witness, Carroll County Sheriff, to ignore a valid subpoena to the detriment of the defense provides a rational inference of bias.
Again, saying it as though it's like actually so, without any citation to, somewhere that's been determined.
Yeah, I mean, case citations help. It gives your pleadings weight.
Right, or even a comparable situation. If you don't have the exact same one, but you've got something similar or something that you can argue this follows the same logic as this. I mean, that's what you're supposed to do.
Oh, look who decided to stroll in at 8:15. Sleuthy. What's up, girl? 35. Judge Gull's failure to fully inform the defense of her involvement in directing law enforcement to ignore a properly issued defense subpoena demonstrates deception. Wow, deception. Whoa, you're putting on your nighttime shades?
Yeah. I was just doing it for those who knew what it meant because I saw them sitting over there.
Oh, the nighttime shades? Well, it's a very, very small group of humans that know all about your nighttime shades.
Well, they've seen the daytime shades.
Oh, they saw the daytime shades when we were doing our lives from New Orleans.
Right.
Yeah.
All right, sorry, go on.
Okay, such deception to the defense provides a rational inference of bias against the defense. All right, so we got the bolded section here. Recent ex parte communication and additional evidence of Judge Gull's favorable treatment to the state of Indiana as opposed to her treatment of Richard Allen and his defense team. 36. On May 3rd of 2024, the defense deposed Sheriff Tony Liggett. During his dep, it was learned that the court has engaged in activities with law enforcement and prison representatives regarding Richard Allen's housing, both during scheduled jury selection in Fort Wayne and during the scheduled jury trial in Carroll County, Indiana. The court failed to communicate any of these plans to the defense in advance of the court's actions. Again, the court appears to have engaged in ex parte communications with the state of Indiana. At the June 15th, 2023 hearing concerning the pretrial housing of Richard Allen, Liggett claimed that the only reason he objected moving Allen to the Cass County Jail approximately 25 minutes from Delphi was due to a lack of manpower to transport Richard Allen and to and from jail.
Do we know if Michael's still here? Because I do not think yes, they are technically the state of Indiana, but I don't think that that's the kind of thing that would be is in good faith to be argued as ex parte communication. But
I mean, typically it's referring to opposing counsel.
I mean, it definitely also refers to witnesses. But again, what we mentioned earlier is this is like the judge has to be able to communicate, or the judge's staff or somebody with the sheriff or whoever else. If there's like a, transportation, security, get somebody over here. Not
Right.
all of that should be, it is what was intended by the no ex parte communication rules.
Right. Hey, by the way, share, like, subscribe, please. Please and thank you. 38. During his May 3rd deposition, Sheriff Liggett acknowledged that Richard Allen was set to be housed at the Tippecanoe County Jail during the scheduled jury trial, and that the transportation of Richard Allen to and from the courthouse was arranged. Whee! I figured it out, Judge. Therefore, there is no need to continue to house Richard Allen at a prison some 2.5 hours from Carroll County during the pendency of this case. I mean, do you know that they were going to transport that dude every day?
Well, according to this, they had some sort of plan, though, that the defense was just unaware of, that they were going to put him in whatever county jail.
Tippecanoe.
Yeah.
Tippecanoe.
But she never communicated that to anyone, so they didn't know that was the plan.
It's because she didn't want them to be aware that there was this alternate plan. Like, I mean, if it's good enough to do it during trial, why not before trial?
And
right?
and that's the argument they're making. And I wish their last sentence under this category focused more on that than the ex parte aspect of it. But I think they keep wanting to focus on ex parte fact aside of it, because that's something you can sink your teeth in as being found to actually raise a reasonable inference of impropriety.
Right. Yeah, I agree with that. 39, according to Liggett, Judge Gull is aware of these circumstances. 40, despite this, Judge Gull failed to communicate or even inquire with the defense about Richard Allen's housing circumstances. for her to know that and
It's
not tell them leading up to trial when they're thinking that, number one, they've got to try. Like, how do you prep with your client when he's 3 to 4 hours away round trip? Like, how do you prepare for trial?
it's
Like,
crazy.
when it's, dude, I've never heard of anything like it. It's insane.
And I do think it's a very strong point that she was aware that the primary concern, which definitely did have to do with the ability to get him in and out of the buildings and get him covered by all angles, security and transportation, that they figured that out
Right. Well,
and
like I
just
said, I
leave him
told
in
you, like,
prison.
I'm rejecting that as somebody who's been to nearly every hearing.
No,
That-
I understand, but all we can do is go based on what they're even, verbalizing. So even what they're verbalizing is no longer an issue.
Catastrophe says that it's 8 hours round trip. She made it even worse. All right. 41. It is also true that despite alternative detention options, Judge Gull has failed to intervene and protect Richard Allen, who at this moment in time is presumed innocent from his appalling confinement conditions by facilitating a more suitable pretrial housing arrangement for Richard Allen while he awaits trial.
She's heard it from 2 sets of lawyers at this point.
Yeah. And like 2 of them handpicked by her. Like
Right.
handpicked.
Handpicked.
42, Judge Gull's actions of ignoring the defense in matters related to the housing of their client while continuing to communicate with the state of Indiana in an ex parte manner provides a rational inference of bias against Richard Allen and his defense team. Your point is well taken. That absolutely should have not have been the focus of the last sentence, because like just the concept of her knowing that and withholding that information from the defense team is shitty. There's no other way to put it. It's a shitty little move by her.
And she could remove him from the prison.
All right. Next section. Judge Gull invited the prosecution to seek limitations on Richard Allen's Sixth Amendment right to prove that other parties committed the crimes in question.
And I'm just going to say, I do think that the defense is not, and there was one of these that we raised that I thought, you know what, she's got a little more discretion and ability than the defense is giving her, is allotting to her. And just because, yes, it's when the judge does something sua sponte that, raises red flags or eyebrows, and she should have waited till the state, brought it up, but she's supposed to control what evidence comes in. So if neither side is doing what they're supposed to do to address it pre-trial, I think that the Supreme Court would say that it is well within the judge's discretion to raise the fact that, hey, neither of you have addressed a significant evidentiary issue that should be best addressed before trial, because I don't want my trial turning into a roadside circus.
Right.
Of us having to have, do everything in voir dire, whatever, in the middle of somebody's testimony, something comes up and you're trying to get something in, you call a witness and then they say, well, we object to this witness being called, and they're supposed to tell the jury to go away and deal with it. So, that being said, but again, that being said, when we first read that letter, I was like, oh, remember, I was like, that's nice, Judge Gull. Let the state know, hey guys, should you argue against this a little bit here? Because I'm gonna hear you on that.
Yeah, and
She
for
did
sure.
do that.
Yeah, and look, I mean, we're seeing it in Reed. Like she kind of allowed third party culprit stuff, but like she's conducting, I like in the 12, 13, 14 days of that trial, there's been many a voir dire, like of witnesses on issues. And like, if you're talking about judicial economy, if you're talking about giving a shit about the jury who's going to be away from their families for weeks, holed up in some rat hole hotel, like handle your shit on the front end. All right. 43, both Gull and the prosecution have known since the filing of the first Franks motion or notice on September 18th, the defense will be relying on third-party suspect defense. In rebuttal to the defense's theory regarding third-party perpetrators, the prosecution listed an Odinism expert on their supplemental witness list emailed to the defense March 17th, 2024. At no time between September 18 and April 27 did the prosecution take any action to prevent the defense from pursuing a third-party perpetrator defense. During this time, the defense conducted many depositions related to the third-party perpetrator defense and, in addition, made numerous requests to the state seeking additional discovery regarding third-party suspects. On April 28, 2024, Judge Gull directed an email to both the prosecution and defense regarding scheduling matters and, without any prompting, informed the defense that she, Judge Gull, was fully aware of the law regarding third-party perpetrator defenses and would be prohibiting the admission of such evidence by the defense unless some nexus between the two could be proven. This unprompted comment was akin to an invitation by Judge Gull to the prosecution to file a motion in limine that would prevent the defense from presenting evidence that third-party suspects committed the murders. 47, approximately 12 hours later, at midnight on a Sunday night, the prosecution filed its motion in limine requesting that Judge Gull not allow the defense to discuss third-party suspects. The court's invitation to the prosecution to seek such limitations creates a rational inference of bias in favor of the state of Indiana and against the defense.
And then before you move on to the next one, I don't know how long Michael's comment's been up there, but I kind of it's a good point by just reading his comment of the way wait, what the you just took down Michael's in the middle of me.
Oh, you needed to continue to read it? I thought you read it, digested it, and read it.
Well, I did, but I was all right. Well, in any
event, there it is.
Okay. So in a way to sort of connect the dots in this kind of motion, when she spoke about, not interfering with the witness and the one above, that she threatened to use her contempt powers, and he's saying which she did not have, in aid of the leak investigation, but no threat to use them on Baston when she actually had them. And that's just the way he just said that just shows more, tying it to how she knows she's got it and she's not using it to help the defense, but using it to hinder them.
I agree. Did you take that comment down or I took it down? You're done? All right. Okay. Judge Gull has repeatedly disparaged Richard Allen's appointed public defenders. We all know what this is.
Yeah. And I hope he focuses on it being what we talked about when Michael was on about it, how it's so close to before trial that it had a high risk of prejudicing him in the eyes of the jury.
Tainting.
Yes. Taint.
Beginning October 19, 2023, Judge Gull began verbalizing her negative feelings about Richard Allen's defense team, using such words as grossly negligent and incompetent. 49. When Richard Allen's original defense team attempted to enter their appearance for Richard Allen pro bono, Judge Gull would not allow their appearance to be entered based upon her view that the defense attorneys were grossly negligent and that Richard Allen could not even expect an adequate defense from attorneys Baldwin and Rosie. And then we got footnote 3 here. Judge Gull stated the following to Richard Allen at the October 31st, 2023 hearing. Mr. Allen, I understand that you wish to have Mr. Baldwin and Mr. Rosie represent you in this matter. I have grave concerns, Mr. Allen, about their representation of you. The previous findings by this court of their gross negligence, Mr. Allen, you are entitled to adequate representation in your case. You are entitled to a vigorous defense in your case. And this is difficult, Mr. Allen, because I know you've indicated that through your attorneys, but I will not allow these attorneys to represent you with the concerns that I've had with the gross negligence that I have found. Emphasis added. In her comments at the October 31 hearing, Gull stated that the following: I cannot and will not allow these attorneys to represent you with the concerns that I've had with the gross negligence that I've found. These words alone equate to outright bias on the part of Judge Gull towards the defense and toward Richard Allen.
Yes,
and
they do.
I agree. Like, how can a reasonable person say that when somebody says that somebody's a piece of shit,
I don't care how objective you can be the most objective person in the world. That is a reasonable inference of bias. I mean, she said it.
You're a
She
piece
said
of
it.
shit.
She wrote it. She
I
said it
know you're a
again.
piece
She
of
wrote it
shit.
again.
You're never changing my mind that you're a piece of shit. You know, everybody that hears her say that, you know what she's going to think about that person?
They're a
That
piece of shit.
They're a piece of shit.
Well, the judge said this defense team is a piece of shit.
All right, 51. Since denying the defense motion to DQ, Gull has continued to show her bias in a variety of ways, including demeaning Richard Allen's two defense lawyers who have between them over 50 years of experience and zero findings that they are incompetent or have violated their professional rules of conduct. 52. Most recently, in her April 30th, 2024 two-page order detailing her ruling on the prosecution's request to find the defense attorneys in contempt, Judge Gull continued her maligning of the defense attorneys, calling them incompetent, negligent, and sloppy in the way that they handled evidence. Furthermore, in that same order, Judge Gull articulated to not only the lawyers, but the general public that she would be referring her findings to the Office of Judicial and Attorney Regulation. Judge Gull's targeted comments in reference to the Attorney of Judicial and Attorney Regulations have no legal relevance to her findings of non-contempt and appear to have been intended to only further disparage the character and fitness of defense attorneys Rosie and Baldwin. While Gull, 54, has on at least 8 occasions denied defense motions with 3 words, denied without hearing. Denied without hearing. I'm getting a t-shirt made and I'm wearing it to the hearing all 3 days in May.
No, you are not.
Oh, yeah. Oh, yeah. Denied without hearing. That's going to be
You know this judge, and she could just boot you just for that. You're not doing it.
Rejected. Judge Gull felt it necessary to use insulting language concerning defense counsel only 2 weeks before the beginning of a trial. There's Michael and your point right there. The fact that Judge Gull continues to disparage the character and fitness of defense counsel when she could have otherwise remained silent on the matter provides a rational inference of bias against the defense. And that's so true.
It is.
Like,
I wish they just would have. I wish they just would have added the words that she did so without regard to the risk of tainting the jury pool.
I agree. Other examples of Judge Gull treating the prosecution more favorably than defense. 56 at the March 18, 2024 contempt hearing, the defense provided evidence to the court that the Carroll County prosecutor, Nick McClellan, interacted with a social media content provider named Gary Baudet, a.k.a. The Fig. The evidence was in the form of emails, including an email in which Fig claimed that McClellan had requested Fig to erase their communications. 57, the defense provided evidence that other leaks occurred over the case's history, implying that those leaks could have emanated from McClellan's office. 58, while Gull is required the defense to cooperate in the investigation of leaks attributed to the defense, Judge Gull seemingly had zero interest in similar allegations attributable to the prosecution.
And if you remember, I kept saying, all right, maybe now the judge is going to say something to the prosecution. She's going to show out even-handed. She's outraged at them. She's mad at them. I've never seen it in any of the allegations, and you know, not all of them, but there were definitely some that warranted her at least inquiring for the state to show that they didn't do this or why they did it.
I could not agree more. Judge Gull treated the defense team differently than she treated her own office regarding allegations of confidential discovery matters. 60, at the March 18th contempt hearing, the defense tendered evidence to Judge Gull that showed that her staff may have leaked confidential information to social media sources. 61, this evidence included emails and video from a content provider named Fig and others, as well as testimony from the other witnesses. 62, and in November 2022, or November 22nd, 2022, social media video tendered to the court, Fig detailed sensitive crime scene information that at the time was not available to the public. Let's go down to 4. The defense attempted to admit Exhibit Q, which was a flash drive containing a YouTube video from November 22nd of 2022, in which Fig announced his knowledge of a bullet purportedly found at the scene when this information was still sealed. Ooh. 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 Yeah.
You're wondering why isn't he? How long do we have to wait for him to press his little button?
That's right. I have so many sound bites I had to scroll through. The judge refused to admit said document as part of her analysis for contempt, but it was accepted as part of the record for the appellate purposes. Pages 139 through 140, records of proceedings at hearing on motion for contempt held on March 18th, 2024. This flash drive is still available for Judge Gull if she becomes concerned either McClellan or someone from her office was leaking information to Gary Fig Budet. Record of proceedings at hearing. That's the citation.
That's a different footnote anyway.
Oh, it is. All right. The defense then attempted to provide emails and did provide testimony to the court in which a witness, Steve Wood, testified that Fig told him, Steve Wood, that his source of that confidential and sealed information was someone on Judge Gull's staff. Oh my God.
Don't do it again. We got
What? Really?
You got to pick one. You either got to make the noise yourself or play the sound.
Okay. All right. 64. Judge Gull has shown no concern whatsoever about unmistakable evidence that on November 22nd of 2022, Gary Fig Budet revealed sensitive crime scene information at a time when the information was not known by the public, later claiming that he, Fig, received said information from Judge Gull's staff. Judge Gull has called the defense incompetent, negligent, grossly negligent, and sloppy concerning the very same allegations against her staff that Judge Gull has apparently refused to investigate. 65. Yes. Yes.
I mean, it's just like they're citing kind of like the same thing through various people and like, whisper down the lane kind of thing. But at the same time, the judge should care enough to at least inquire to someone about why it is it's being said, But you're talking about like quadruple hearsay here. Hearsay upon, I don't know, social media video.
Which is hearsay. No one has any idea what investigation Gull has done.
I mean, it's true.
That is true. That is true. And I think that might warrant the sound. Just won't play.
Won't play?
Yeah, it must hear you. I think
Jay disabled it.
I think AI is controlling this thing. They're like, you know what? You've done the dun thing enough, buddy. You're done.
Right. And to Michael's point, you and I have said that, like, well, maybe she actually is, looking into this stuff outside of us, but I would have assumed that the defense would know if she was, but maybe not. I mean, she could have looked into it. She could have watched it. She could have.
Doubtful.
Gave a little smack of the hand
to her staff.
Yeah.
Yeah. I mean, doubtful. The defense has no idea whether Judge Gull's court staff leaked sensitive information to a social media site, but there does exist facts to support this allegation. Despite these facts, the defense is aware of no action taken by Judge Gull to investigate these circumstances. This is in stark contrast from the actions of Judge Gull, who in the fall of 2023 endorsed the prosecution and its law enforcement personnel in seeking out suspects associated with the leak of crime scene photos to the public. The fact that Judge Gull has treated the defense differently when the defense is accused of a leak than it has treated her own staff or the prosecution creates a rational inference of bias against the defense. Next section. Judge Gull wrongly blamed the defense for ex parte filings, which were inadvertently directed to the prosecutor. 66, the defense learned from prosecution filing. The prosecution, remember that great filing?
Yes.
So I was reading this ex parte motion filed by the defense.
Right. So Bob's referring back to an old motion filed by the state wherein they quoted an ex parte filing by the defense. And again, ex parte means only one side's laying eyes on this. If the defense files a motion ex parte, the state does not get to see it. So we were, so it all begged the question: how in the hell does the state know what the defense wrote in an ex parte motion?
Exactly. Yeah, I think
it's outrageous, egregious, preposterous.
I love that one.
Yeah, it's Jackie Childs. The defense learned from a prosecution filing that the prosecution had somehow received Mr. Allen's ex parte documents that were not to be viewed by the prosecutor. Upon inspecting how this happened, the defense determined that Judge Gull's staff or the Carroll County clerk errantly misdirected these documents to the prosecutor. When defense counsel, whoopsies. When defense counsel staff reached out to Judge Gull's staff to determine why and how multiple ex parte motions had been sent to the prosecutor, Judge Gull, without investigating the matter, fired off an email to the defense disparaging its staff and placing the blame on the defense. 69.
And by the way, the judge should have taken that opportunity to say to the state, by the way, you knew damn well when you were sent an ex parte motion, you weren't supposed to see it. You should have deleted it and not reviewed it.
Did I hear the guy?
Yeah, Nook's
Katie,
angry too.
That's the verdict. He's
Nook's
angry.
outraged.
He's outraged.
I might have to
the
go
verdict. Paul Newman, great movie. Great movie. It's civil litigation, but it's still a great movie. All right. So 69, having been accused by Judge Gull of making the mistake, the defense staff member who filed the ex parte motion then reached out to DocsPop to make sure that she was filing the ex parte motion correctly. It was determined the defense was filing the motion correctly. The entity responsible for sending the ex parte motions to the prosecution, therefore, was either Judge Gull's staff or Carroll County clerk. 70. Rosie then reached out to Carroll County clerk, who maintained that she had correctly handled the ex parte documents. Process of elimination, babe. Who's that mean it was by? Who did it? Who did it?
Who did it? That would
she
leave the judge's staff.
Did she do it? The defense is in possession of screenshots which prove that the defense counsel staff filed the ex parte matter confidentially, and that proves that the defense staff provided service only to attorneys Rosie and Baldwin and not McClelland and any other person. This is the proof the defense staff followed the rules for filing ex parte motions. The defense did not send out the ex parte motion to McClelland in spite of Gull's quick accusation.
So I would say that an objective person looking at how for her first visceral reaction to assume the defense did something wrong is a reasonable inference of bias, objectively speaking.
I would agree. 72. Gull failed to investigate how such a significant error could have been made to avoid misdirected ex parte filings in the future, but rather simply blame him on the defense. Blame it on those guys. They're incompetent, sloppy, lazy, shiftless, worthless. Judge Gull's reaction in blaming the defense for the ex parte leak of the information when the leak appears likely to have emanated from Judge Gull's own staff shows a rational inference of bias.
And what I would have added there as paragraph 74 and 75 is that the defense is unaware of any reprimand that the judge gave to the state if they are inadvertently, accidentally sent something that they shouldn't be laying their eyes on. And we know of two. One was the text messages, and now this, where the judge, to their knowledge, has not reprimanded the state for doing that. And that also shows a difference in how she is treating the state versus how she is treating the defense, because that's absolutely what she should have said to them in that regard. Absolutely. Like, I don't even understand how that's not an issue in her mind.
Oh, I know. I mean, you were the second that became like kind of public knowledge, you were like, all right, here we go. Finally, Nick's going to get a spanking in open court. We're going to see it. And nothing, honey.
I was holding out hope. All right, I'm going to go do something with our little guy over here.
Oh, I bet you are. Accusations of violating rules on access to court records. 74. Due to the way that Gull maintained the records on this case, attorneys Margaret Smith and Kara Winnicke entered their appearances and filed a petition for a writ of mandamus and prohibition. Following Smith and Winnicke's original action for writs, Gull hired a lawyer, and then it was forced to cure most of the issues that Smith and Winnicke identified prior to the hearing in the Indiana Supreme Court. In other words, Judge Gull and her attorneys recognized that she had errantly violated the rules on access to records and then cured those errors, calling the defense incompetent, grossly negligent, and sloppy, while ignoring the fact that both the court and the prosecution have been accused by others of behavior that might or would be considered incompetent, grossly negligent, or sloppy, provides a rational inference of bias. Next section, defense motions are treated differently than those of the prosecution. While at least 5 outstanding defense motions were pending related to the merits of the case, all which need to be ruled on as soon as possible for purposes of trial prep for the defense, Judge Gull chose not to issue orders or set hearings on any of those motions. True story. Instead, Judge Gull chose to spend valuable court time setting a half-day hearing on the prosecution's motion for contempt. True story. Prosecution's motion for contempt did not address the merits of the murder allegations against Richard Allen, nor was a contempt motion a time-sensitive matter. True story. 79, there is no reason that the contempt hearing could not have taken place after Mr. Allen's trial. True story. I said that 5 million times. The prosecutor filed his motion for contempt against the defense on January 29th, 2024. 3 days later, February 1st, Judge Gull issued an order setting the matter for hearing. The defense had never received such a quick setting on any of its motions. 81, even at this moment, several outstanding motions have yet to be ruled on. 82, for example, the record shows that on more recent pleadings filed by the parties, Judge Gull quickly prioritized the prosecution's request for contempt over the following defense motions. A, the motion to suppress confessions. Defense filed this motion on April 11th, but it was ignored by the court until the recent May 7th, 2024 hearing. Again, it took Judge Gull only 3 days to file a written order addressing the prosecution's motion for contempt by setting it for a hearing only 2 weeks later, while Judge Gull failed to even acknowledge the defense motion for suppression of the confessions for nearly a full month, and then only did so at that hearing. The motion to suppress the accused's second statement. The defense filed this motion on April 15th, 2024, but it was ignored by the court until May 7th, 2024. Again, it took Judge Gull only 3 days to file a written order addressing the prosecution's motion for contempt by setting it for a hearing only 2 weeks later, while Judge Gull failed to even acknowledge the defense motion for suppression of the accused's second statement for over 3 weeks, and then only did so at the hearing. The motion to compel and for sanctions. The defense filed this motion on April 23rd, but it was ignored by the court again until May 7th. Again, 3-day thing. She didn't acknowledge it till the defense motion or until the 2 weeks later, and only did so at the hearing. That like she had the housekeeping thing where she's like, "What are all the outstanding motions?" And then started setting them. Kind of. She acknowledged they existed at least. I'll say that. Motion for Franks 3. Defense filed this motion on March 13th of 2024. Gull has ignored this defense filing for 62 days. Now, again, it took Judge up through May 14th. Again, it took Judge Gull only 3 days to file a written order addressing the prosecution's motion for contempt by setting it for a hearing only 2 weeks later, while Judge Gull failed to even acknowledge the defense third Franks motion up until the time of this filing. So E, ruling on the first Franks. Additionally, while it took Gull over 4 months to rule on the first Franks motion, it only took Gull 43 days to issue an order on the prosecution's request to find defense attorneys in contempt following a half day of testimony. 83. The prosecution's contempt motion is not relevant to the merits of the case, while the defense's various motions described above are relevant to the merits of the case. Yet Gull acted on the prosecution's motion within 3 days while ignoring the defense motion for weeks. Judge Gull ignored other older defense pleadings, sometimes for months before ruling. Many defense motions have resulted in Gull issuing an order saying these 3 words: "Denied without hearing." Since their reinstatement alone, Judge Gull has denied defense motions without hearing a total of 8 times. including denying motions to compel discovery, which Mr. Allen needs to prepare his defense. 85, Judge Gull's quick treatment of the prosecution motions on matters ancillary to the innocence or guilt of Richard Allen versus Judge Gull's treatment of the defense motions that are related to the merits of the case provides a rational inference of bias for Judge Gull's bias for the prosecution and against the defense. Certainly, it appears that Judge Gull used the prosecution's motion for contempt as a vehicle to malign the defense while simultaneously ignoring matters raised by the defense that would malign the prosecution for its handling of discovery. This provides a rational inference of bias against the defense. Next section. Gull ignored the defense's request to set aside 2 weeks to present Mr. Allen's defense while refusing to set any time limits on the prosecution. I hope I didn't read this ahead of time. I hope they make my argument that was her plan the whole time, setting that trial date, forcing them to come in and ask for a continuance. And I'm talking about the duration of it, putting the duration. So on or about October 4th, 2023, Mr. Allen's counsel notified the court that they would need approximately 2 weeks to present his defense. In the aforementioned April 28th Sunday morning email, Judge Gull sua sponte issued a stern message in the email indicating that the trial would end on May 31st, 2024, not more or less. Before issuing her orders on the days allotted for trial, Judge Gull failed to reach out to the parties in order to determine how many witnesses were expected to testify, the expected length of their testimony, how many videos were expected to be played, and the length of those videos, and most importantly, how long each side expected their case to last based upon the evidence that they expect to be presented. 90, between all defense counsel with a combined 70 years of experience, not one time have they been told that a trial would absolutely end on a certain day and not go any longer. We never heard it before either. It's crazy. You know why? Because it's crazy. Judge Gull's inflexibility only impacts the defense as the prosecution presents its case in chief first, and therefore likely would have enough time to put on its case, leaving the defense with little or no time to put on its case in chief. Richard Allen possesses constitutional rights to the compulsory process of having witnesses testify on his behalf and to confront witnesses pursuant to the Sixth Amendment of the Constitution of the United States, as well as a right to present a complete defense pursuant to the 14th Amendment. 93, when the defense asked Gull at the May 7th hearing if the state of Indiana would be forced to abide by the same time constraints as the defense, Judge Gull would not commit to such a requirement of the prosecution. Out of fear that the prosecution would run out the clock and leave the defense with minimal time to present its case, Judge Gull forced the defense to accept her remedy, a continuance of a speedy trial. You must continue the speedy. Because of Judge Gull's refusal to guarantee the defense the same amount of time for trial as the prosecution, Richard Allen was, for all intents and purposes, denied his right to a speedy trial.
He was compelled to waive it.
He sure was. 96. All of the above circumstances create a rational inference of bias against the defense and in favor of the prosecution. Okay, so now we're getting into some of the, I don't know, this stuff. Judge Gull engaged in extrajudicial activities that raise a rational inference of bias, especially when Judge Gull may have to rule on how the extrajudicial activities of a key state witness will impact the admissibility of Richard Allen's purported confessions. So Judge Gull was appointed to preside over this case on November 4th of 2022. Since being appointed as special judge, this case has become one of the highest profile cases in recent memory, even receiving worldwide attention. The victims of the murders are Abby Williams and Libby German. On July 9th, 2023, more than 8 months after being appointed to the case, Judge Gull chose to comment on a post concerning a softball tournament at the Abby and Libby Memorial Park. The post upon which Judge Gull was commenting stated, quote, "What an honor it was for the girls to play in the Abby and Libby Memorial Tournament. What a great honor it was that Abby and Libby's grandparents were present our girls with their championship finalist rings."
That is actually problematic. That's a legitimate problematic thing. She should never have commented on that. I mean, wow.
Oh, you hadn't heard this before?
No.
I had heard this independent of this this
Oh,
motion.
that wasn't the judge's comment. That was the post she commented on.
Right.
Okay.
Yeah.
All right. I mean, whew, but it's she still shouldn't have commented on that post. I was thinking that was the post that she wrote.
Her comment was congratulations.
Right. Mm-hmm.
While seeming innocuous, Judge Gull's choice to comment on a post involving a softball tournament celebrating the lives of the victims of the crimes in which Judge Gull is the presiding judge was inappropriate. I agree.
I think it was.
This guy tell that story about, like, I was over at Hardware or wherever, and somebody just got on the bench over by us. And I was like, oh, congratulations. You know, can I buy you a beer? And they're like, nope, I don't even want, like I can't even take a beer from you because it smacks.
Yeah, and we've got a friend who's married to a judge, and she was invited to Bob's birthday party, and she wrote back like, by the way, I can't bring my husband. He can't, commingle with the lawyers like that.
Yeah.
And it wasn't we didn't have any like specific case going on in front of him, but we are, often in front of him, but but lawyers and judges commingle at like events, legal events, bar events, things like that. But it just shows, like you're saying, that most judges will just go out of their way to avoid,
reading. I love you. Did you
avoid anything.
Mall?
Yeah.
Good. Did you buy anything?
Yeah.
Oh, I want to see it when we're done. All right. Certainly 103, certainly when factoring in the other issues raised in the first motion to have Gull disqualified, as well as the issues raised in their second motion to DQ, Gull's comments were even more inappropriate, providing an appearance of bias against Richard Allen in favor of the state of Indiana, who is prosecuting the accused murderer of the victims who are identified in the post. 104, the defense believes that Judge Gull's choice to comment on social media as detailed herein on its face supports a rational inference of bias as well as an appearance of bias. 105, however, newly discovered evidence adds another layer of conflict and bias to Judge Gull's post. On May 6th, the state of Indiana filed its formal request for a pretrial ruling on admissibility. Within said request, the state referenced Cam's calling me. See what's up.
I don't have my phone.
I'll
go grab it.
The state of Indiana filed its formal request for a pretrial ruling on admissibility. Within state request, the state referenced Dr. Monica Wall as being a psychologist providing services to offenders at Westville Correctional, one of those inmates being Richard Allen. Subsequent to the filing of said pleading, members of the public began to discover that Dr. Walla had joined and participated in social media forums, outlets, etc., involving the Delphi murders. Naturally, these facts were reported to the defense through various means, including defense diaries. She was definitely in our group and in our chats. It is also true that defense deposed Dr. Walla on Wednesday, May 8th, at the offices of Hillis, Rosie, and Dean. The DEP was not completed due to timing constraints and will likely be reset in early June, at which time the defense expects the depositions to conclude. 108, the defense was unaware of the apparent social media activities of Dr. Walla at the time of the deposition, and therefore the matter was not addressed. It wasn't until shortly after the DEP concluded that these issues were brought to the attention of Attorney Rosie, who conducted the DEP. Since May 8th, the defense has become aware of information that suggests that Dr. Walla did, in fact, engage in social media activities related to the Delphi murders. What is that noise?
I'm sorry. I was texting with our daughter.
Oh, the defense is not in a position to determine the extent and nature of said activities at this juncture without conducting further discovery. However, the defense is aware that the online personality purporting to be Monica Walla, including a picture of Dr. Walla, appears to have been deleted, removed, and or wiped clean of any online presence related to the Delphi murder. She definitely dropped out of our group. This appears to have been done in the hours following the deposition referenced above. Hey, can you put your thing on silent, Bay?
I did it, but because she's like ignoring the thingy.
Okay. I'll work past it. Again,
Sorry.
this court is faced with a conundrum.
Can you hear me now, though?
Yeah, I can hear you.
Okay.
I could always hear you.
Silented. Well, I just silented my computer, so I
Oh,
didn't know
okay.
if that was gonna.
Again, this court is faced with a conundrum. The judge's decision to publicly comment on matters involving the death of 2 girls is evidence that Judge Gull does not find it inappropriate to engage in such communications about a pending case. How then can Judge Gull be impartial in making any determination of the defense's motion to suppress or the state's request for a pretrial ruling on admissibility of communications between Richard Allen and his state-appointed psychologist? If this court were to find that Dr. Wall's alleged acts were inappropriate, then by extension, the same could be true about Judge Gull's actions. Bit of a stretch, but I mean, I see what they're saying. I don't know that Walla did anything out there. Like, I don't know if she ever commented. I mean, it's one thing if they find something where, like, she said something like, "Hey, guess what? This dude, he confessed to me, and this is what he said." Then she's got some problems, But I don't know that anything like that exists out there. That would be insane. It'd be like professional suicide.
Well, it's still very. I find it very problematic that she's.
It's certainly inappropriate.
Forums, yeah.
It's certainly inappropriate. Like, I mean, I think that she was in them, some of them prior to. She joined ours the date of the safekeeping hearing in June, like the day of. That's when she jumped in ours, which is weird. As the purported confessions loom as potentially the most powerful evidence against Richard Allen, any appearance of bias or conflict that exists for Judge Gull as she makes determinations of the legal impact of this witness's social media activity on those purported confessions provides a rational inference of bias.
And I just want to comment because I caught very little of Teresa's live, but the part that I did catch, she said that she has been able to confirm, like through her contacts and whichever way, that identity did belong to the actual person.
Yeah, I saw that as well. And she got it from like a reliable family type source that she was never going to give up. She's like, "Hey, you can either take my word for it or go fuck yourself." But like, I'm confirming it, and I trust her, so I take it as good as gold. Okay. Additionally, even when Judge Gull rules against the defense and does not suppress the purported confessions, Judge Gull will likely face a second legal argument: the admissibility of any social media postings of this witness that involve the Delphi murders in order to attack the witness's credibility. Should the prosecutor object, claiming that this witness's social media comments on the Delphi case are inadmissible, Judge Gull will once again find herself in a conflicted position due to her own social media comments concerning a post involving the victims of the murders. 113, Judge Gull's starting position apparently is that it was appropriate for her, Judge Gull, to choose to comment on a social media post concerning the victim's softball tournament.
Oh,
Therefore,
I weigh the fact that she did it. That is her position.
Yeah, I mean, it's definitely her position. I mean, like, Gull's got to be sitting there.
There's no way that she didn't think about that before she did it.
There's no way she didn't think about that. Like, zero chance.
Has Michael been listing some of this good stuff not used? We definitely put up one. I wonder if there's more out there that we're not seeing. Anyone, if he posts any, let's get him up there.
Yeah, DB. I mean, it's her. I mean, like I trust.
That's what Teresa said in criminality, that she was able to do her due diligence to the point that she felt confident that was in fact her. And a point that she made that I don't know the timing of when she was popping up, but the point that Teresa was making, like, to the public, which was very well taken by me anyway, was, if the identity existed before she was a person of interest, Why in the hell would somebody make a fake identity for someone that didn't matter? Someone
Right.
they never heard of. Someone no one's ever heard of.
Right. Okay. So 114, therefore, it would be more likely that Judge Gull's starting position will also be that it is Dr. Wall's social media post activities are similarly appropriate. With this starting position, the defense will face a heightened burden in arguing for the inadmissibility of Dr. Wall's social media post activity. This additional hurdle, created at least in part by the court's inappropriate comments on social media, creates an inference of bias or prejudice against Richard Allen. DQ recusal is the appropriate action in terms of remedying this prejudice. Judge Gull has impaired Richard Allen's ability to defend himself by denying his reasonable request for expert and administrative staff funding.
I mean, she did give the prosecution like a whole budget for staffing or something. I'm sure we'll hear about it right now. There you go.
Yeah. In 2023, the defense tendered bills for matters related to their defense of Richard Allen, totaling over $38,000. Judge Gull has not authorized payment of those bills as of the date of this filing. 117, defense counsel has been forced to advance those expenses out of their own pockets. For example, defense has paid $26,000 large for the work its investigator performed in the spring, summer, and fall of 2023. When Gull was not satisfied with the format of the investigator's bill, the defense tendered a new bill to meet the court's expectations. Because the investigator deserved to be paid for the work he performed, the defense paid the investigator out of its own law firm account. After trying to rectify the issues Judge Gull had with the bill's format, Judge Gull has failed to order the payment of such expenses associated with the defense's private eye. The defense has sent multiple requests to Judge Gull and her staff seeking input as why this bill has not been paid. Judge Gull has not responded to those requests. The lack of response to these requests for payment creates a rational inference of bias. Also, while the prosecution has unlimited access to funds and law enforcement experts, Judge Gull initially denied the defense request for expert funds for certain experts needed for the defense of Richard Allen. Only after the defense filed requests for reconsideration and apparent public outcry did Judge Gull change her mind and provide the defense funds for these experts. The refusal to initially provide funds to the defense for expert provides a rational inference of bias. Evidence that public confidence in Judge Gull has eroded due to continued improper conduct and conduct that creates the appearance of impropriety. Evidence of the erosion of the public's confidence in Judge Gull can be shown through letters that Judge Gull has received, as well as letters the Indiana Supreme Court has received, as well as memes. Memes.
What?
Memes.
Are there pictures?
Meme. I mean, somebody sent me a meme. I haven't seen any of these Gull memes. As well as memes and other social media content that can be easily located on the internet.
Are these by objective people? Are they creating the memes?
Subjective people or objective people? They're definitely.
That's what I'm saying. They're supposed to be objective for this test. So that's what I'm saying.
They're definitely subjective. Find attached.
Not objective.
They're they're not objective. They're subjective.
Right. Well, okay.
Yeah, they're very subjective. Find attached 14 letters and emails that members of the public have taken. We don't need to. She didn't need to attach them. She puts them on the docket.
No, I know. I was asking about the pictures.
I'm talking to these guys. Like they're
just creating a record. They're just creating a record.
Yeah, of emails that randos send a judge on a trial. I've never seen anything like it.
Hey, these are objective people voicing concerns about her impropriety.
Yes, ma'am. Find attached 14 letters and emails that members of the public have taken the time to draft and sent either directly to Judge Gull or to the Indiana Supreme Court. These letters and emails provide evidence that the public perception of Judge Gull's ability to be fair and impartial has eroded. Multiple people. Where's that thing? Oh, 6 down here. Multiple people paying attention to this case believe that an inference of bias and prejudice against the defense exists to such a degree that they took time to alert this court and the Indiana Supreme Court to what they are observing. So on March 28th, Paige Moore wrote Judge Gull, among other things, Mr. Allen was denied funds for expert witnesses. Even though Americans are guaranteed a fair trial, experts are needed for forced confessions and bullet markings. On April 1, Oscar Lopez wrote to Judge Gull, among other things, I have serious doubts that you, the judge presiding over this case, is capable of being fair and impartial in this case. On March 29th, Lisa Trick wrote to Judge Gull, among other things, you are the most biased judge I've ever seen, and you ought to be ashamed of yourself. This is not a fair trial. March 27th, LGW wrote Judge Gull, among other things, it appears the defense is being prohibited from being able to defend their client. On 28th, Stephanie Cope wrote Judge Gull, among other things, the following. I have watched every phase this case has gone through, like many others. It's shocking and disturbing seeing Mr. Allen and how his public defenders are treated so unjust. I can't understand the lack of self-awareness you have concerning your own biased feelings. On March 29th, Hope Douglas wrote Judge Gull the following. In my opinion, it is clear as an outsider looking at this case that you have presented your rulings as biased and almost always pro-prosecution. I don't know if that's where it ends, but it's where I'm ending it. Okay, so the perspective of common everyday citizens, i.e. objectively reasonably people. Objectively reasonable people.
He used objectively reasonable people. I don't know.
Double down.
Objective people. Reasonably.
They're reasonable people.
Right. Objective.
Right.
They're objectively reasonable.
Listen, I'm being very objective here. They're reasonable people who have taken the time to voice their concerns about the apparent bias that they're witnessing should not be overlooked. Judge Gull has refused to order the state to comply with discovery rules to the detriment of Richard Allen. Indiana Code of Judicial Conduct 2.6 states that the judge shall, according to every person who has a legal interest in the proceeding or that person's lawyer, the right to be heard according to the law. Comment 1 states that the right to be heard is an essential component of a fair and impartial system of justice. Bolded, substantive rights of litigants can be protected only if procedures protecting the right to be heard are observed. Right.
That means not saying denied without hearing.
Right. All right. Comment 2 discusses the important role the judge plays in overseeing the settlement of disputes, indicating the judge should be careful that efforts to further settlement of disputes do not undermine the party's right to be heard according to the law, and that the judge should keep in mind the effect that the judge's participation in settling disputes may have not only on the judge's own view of the case, but also on the perceptions of the lawyers and the parties. That's what we were arguing. Taint! If the case remains with the judge after set efforts are unsuccessful. Emphasis added. ICJC 2.7 states that, quote, a judge shall hear and decide matters assigned to the judge except when disqualification is required by 2.11 or other law. Comment 1 states that judges must be available to decide the matters that come before the court. So the defense incorporates paragraphs 1 through 134. Is that how many paragraphs I've read?
Yes, sir.
Wow. It's been a lot. In support of Judge Gull's violation of IJC or ICJC 25, 26, and 27. 135, Judge Gull has held only 2 hearings with current defense counsel since June 15th of 2023, and one half of the March 18th, 2024 hearing pertained to the prosecution's hearing on contempt unrelated to the merits of the case. 136.
I think there is something to be said that she felt it more important to address that than to address all the pending motions that were substantive motions that affected the actual case.
That is undeniable. That piece of shit motion could have waited until after trial. Like, you knew their hands were tied. She couldn't do shit. Like, these people, like, oh, they're gonna boot her off the case again. No, they're not. They're not booting him. That thing was absurd. Even though the defense has filed several motions seeking hearings on discovery matters that are deeply impacting the defense, Judge Gull has ignored the opportunity to assist in the resolution of those matters, either through a hearing or some other means. Yes, Michael, that is correct. They should be seen and not heard until they're required to be heard. Judge Gull's refusal to act on discovery disputes raised by Richard Allen raises a rational inference of bias. Judge Gull has only allowed cameras in the courtroom once at the hearing when she knew one way or another that she was kicking the attorneys Rosie and Baldwin off the case. Rule 2.8b states that a judge shall be patient, dignified, and courteous to litigants, jurors, witnesses, lawyers, bolded for emphasis, court staff, court officials, and others with whom the judge deals in official capacity, and shall require similar conduct of lawyers, court staff, court officials, and others, subject to the judge's discretion and control. What's good for the goose, it's good for the gander. The defense incorporates paragraphs 1 through 138 in support of its contention that Judge Gull has violated ICJC 2.8. 140. Man, I'm so close. I could taste it. Judge Gull has won one of the test course for cameras in the courtroom and appears supportive of cameras in the courtroom. However, the only time in this case that Judge Gull has specifically allowed cameras in the courtroom was on October 19, 2023. On that date, Judge Gull knew going into that hearing that she would either allow Baldwin and Rosie the opportunity to withdraw or proceed to the hearing in which she would read into the record a handwritten document she penned before the in-chambers hearing, disparaging and discrediting Baldwin and Rosie. Judge Gull's attempt to disparage the defense counsel with cameras in the courtroom, again, the only time cameras have been in the courtroom, violates ICJC 2.8 in addition to all other facts pled herein. It would be difficult to believe that an objectively reasonable person would not believe that Judge Gull has demonstrated bias and prejudice against the defense. Her own words, grossly negligent, incompetent, and sloppy, are proof of these obvious facts. Beyond Judge Gull's words lie her actions. They are articulated throughout the body of this motion. Actions often do speak louder than words. The actions of Judge Gull warrant her recusal and or disqualification. The defense is requesting that this court to restore public confidence by withdrawing from this case. The defense is requesting that this court to disqualify itself to reduce the likelihood of costly appellate litigation and the cost of a retrial should a negative outcome against Richard Allen result from the trial, should she remain on the case. The cumulative effect of each piece of bias and prejudice recited herein supports the defense request for a change of judge. Richard Allen, a man presumed innocent, deserves a fair trial, as do the victims' families and the entire Delphi community. Judge Gull's continued involvement in this case will leave a cloud of doubt over the legitimacy of the proceedings. And that's very true. It's very, very true. Like, it's just like the people that are of the mindset that she's beyond bias are always going to feel that way. There's no way she can cure it at this point. It's incurable. It is not a curable thing. There's nothing that she could say or do that can undo the words that she's spoken and written publicly about these lawyers. There's nothing she could do. Accompanying this motion in the affidavit of Richard Allen, which the defense requests to be incorporated in this document, the same affidavit sets forth the facts establishing the timelines of defendant Allen's request for a change of judge pursuant to 2.4C2. And finally, this motion is also accompanied by a certification that Richard Allen's attorneys believe in good faith the facts recited in the affidavit are true and accurate. Boop. Signed, Richard M. Allen. Two times. All right, and then there was his affidavit.
You don't need to read it. It just says,
yeah, he reviewed all the facts and everything my lawyers say is right. She's got to go. That's a summary. That's it. All right. So there you go. There you go. What do you think? What do you think of that?
I just kind of hope she doesn't deny it over the weekend. I mean, she's got like 2 days, not including the weekend, to deny it if she actually wants to be able to proceed to hearing.
I mean, they had to
on the
file
other
this
stuff.
to make the record, you know? I mean, when you look at it all, and some arguments are tenuous, some are very strong. There's nothing stronger than her continually belittling his counsel publicly. Like that, you just can't do that. Like the final straw in terms of like her really showing her ass in terms of her bias was in her order for the contempt. You know, finding them that she couldn't find them in contempt because McClelland didn't make the case, didn't meet his burden, but just had to throw in there. Despite that, I still think that you're sloppy, incompetent. Like she says she still thinks that they're sloppy and incompetent. Like there's just like, how can anybody that reads those words try sending a $10 sticker about 50,000 times? I mean, for as much as I've been on all day, didn't get much love in the super chats. I'm
Well,
not
she's
gonna lie.
saying that she's saying that
I
she
mean, in
wasn't able to
general,
send
I
it.
ain't sweating Katie. I know she's been there all day. She's
All right,
very
well,
vocal in the chats. So I don't know. I don't know, to be honest with you. It's like, you know, I like Kara had made a comment that she had kind of hoped that they would wait. Thank you, Rochelle. Thank you so much for a super sticker. Wow. Thank you. I appreciate that. I think 10 hours deserves something on here. I don't know.
all right, come on. We
Whatever.
just speak.
Oh, it's been a long day of working. So, you know, like, I don't know if I like agree with you that like they should have filed this beforehand. I mean, like, let me ask you this. If this is denied without hearing, what can they do?
They're gonna file an interlocutory appeal, clearly, unless they're gonna go, I mean, right to the Supreme Court, but I doubt that. I don't know.
Yeah, I don't know. I mean, she can't sit on this case. She just can't. You know, oh my God, my guilt trip worked. It's amazing. Over the years, Allison has really taught me Jewish guilt. It's such a great
What the
thing.
hell?
It's true. It's
I
true.
think that Catholics have the thing on guilt.
That's true. That's true. You know, they make you feel like very, very bad about doing things. Thankfully, I was never indoctrinated into any organized religion. So I don't know. I just run around like a freak,
Yeah.
doing whatever I want, saying whatever I
Degenerate.
want. So refusal to pay is bad. About $600 for high capacity external drives. I agree. And I'm assuming that because it wasn't listed here, is the fact that I think Rosie must have gotten paid. Like he had an outstanding invoice forever. They didn't list that. So I'm assuming that these guys got paid their fees.
I haven't seen an order about paying the new lawyer, and I haven't read every single thing that we get sent. So maybe it's out there.
Yeah, maybe. I don't know. I think, well, apparently, and thank you guys for those $10 hollers. I appreciate those. Apparently,
Rochelle did 20.
like we didn't know, like she paid on the down low, like the fees for experts. Like she didn't issue an order. Like, you know what I'm saying? Like that wasn't out there for public consumption. That
Right.
she had ponied up the dough. So, I mean, maybe she's doing that on the sly. Like, why? Like that shows bias to me. Like she can't even put on the record that she's just paying the fees and that she should be paying because she doesn't like what is that? I think the fact that she doesn't make that public knowledge also shows bias. It's a weird thing to do. It just is. So all right, you know, I mean, I'm going to go to the hearings. I mean, she's conducting a lot of stuff, you know, so, and obviously I will be reporting live each night as to what went down since she doesn't televise anything. You know, and I'm curious, like, you know, I mean, that third party culprit stuff is so big. And I just don't like how she's not seeing a nexus. Like how, like Michael said it. How can you have the statements of Alan, these confessions of Alan? How do those have weight? How do those create a nexus between him and the crimes, where Elvis Fields in his confession do not? Like, I mean, she'll let me in. I never name call her ever. Never once ever called her a name. What are
I'm
you saying?
sure we-
For? I've never
I'm
called
sure
her.
we-
any name.
I'm sure we disparaged her in some.
I have not.
form or
I have been very critical of her. I've always been respectful of her.
Well, yeah.
Well, but that, like, you did like, I've never name called her ever anywhere in print. On, like, you know, I think that she's been incredibly biased, and I think that she's run this case like shit. And that's my honest opinion. And, you know, if she sees this and doesn't like it, well, too bad. I'm allowed to have my opinion, and that's what it is. So sorry, not sorry. So, all right. I think that'll wrap it. It's been a long 3 hours. My boys over at Publicly Buzz, I ate into their time again. I have once again set the portal. So if those guys are still rolling over there, I hope that you guys will hang in with them because they're my bros and I love them.
And don't forget to minimize the chat and hit that thumbs up on your way out.
Yes, like, share, subscribe, please, 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 like, share, subscribe.
Have a good weekend, everybody.
A very small thing that could have a big impact about getting us out there. Like when you're searching, like if you search, like, oh, Delphi, like, we pop up, and we think we put important info out there. So, so please, yeah, like, share, subscribe, and we love you guys. Thank you so much for hanging with us. Thank you so much for our mods who also had very, very long work days as they kept our chats cool all day. And these always, like, these Delphi ones get way more heated than Reed. Yeah, not really. You know, it's like Reed gets pretty.
Did you get that?
I did, Alicia, today. Thank you very much. Thank you for reminding me. I literally just opened them today. So thank you for me, for sending those to me and Allie. We really do appreciate that. All right, you guys.
Catch shit for wearing it. Like, how dare us? Because people think we're.
Yeah. Like, look, you guys are the best in the business. You guys are the best chat, best community. We love you guys. And just remember, without you, I'm an old man
Talking about a lot of cases.
Ooh, girl, you ain't never lied. Later.